Joint Legislative Ad Hoc Committee on Family Court Orders is called to order. If the Secretary please note the roll. Thank you. All right, first up on the schedule today, we've got a little modification on those that are going to testify. We have the pleasure of having Kathy Sherlock, the mother of Caden Sherlock, who was murdered by her biological father. And that is the genesis, I believe. I'll let Kathy speak to it. But that's the genesis of an addition to federal law called Caden's Law. So, Ms. Sherlock, would you like to step forward to the microphone? And if you would, give your name and just briefly where you're from. And then you got about 15 minutes to tell your story about Caden's Law. We need to have you pull the microphone as close as you can to yourself. Speak directly into the microphone.
Hello?
Because this is being live broadcast.
Okay. So I'm going to face you.
You're going to face us.
Sorry.
If they want to see your beautiful face, they'll have to watch it later on TV after it's, because it is simulcasting now, but it will be recorded on the legislative page. Okay? So if you would, please give your name and where you're from.
Hi, my name is Kathy Sherlock. I am from outside of Philadelphia, Pennsylvania, Yardley, PA. I am the mother of Caden. Her name was Caden Mancuso, actually, but we just call her Caden. So, and I am here to, well, first I want to thank the Senate of Arizona for having me out here, me and my people. We appreciate you, and thank you so much for having us, and we really are appreciative of it. Obviously, I'm from Pennsylvania. Along with my crew here, we now have I guess it's the responsibility of, unfortunately, I don't know how you look at it, going state to state trying to get Caden's Law passed in every state in this country. Caden's Law was passed under the Federal Law Act under VAWA under President Biden in 2022 under the reauthorization of VAWA. Just a little bit of a background. I'll give you the whole story in a second. Just wanted to give you that reason onto why maybe we may be here. We are in 10 states so far. Pennsylvania, my home state, took 5 years. It was not the first. It was probably the fourth or the fifth. I believe Colorado was first, then California, Utah, and Pennsylvania, and so on. It goes from there. So some of you may not know my full story, so it's hard to wrap up how do you tell your story in 10 to 15 minutes. I'm going to try my best to give people the best background. So of me, my story, my daughter, and kind of how I got here. Unfortunately, I'm going to have to read, and I apologize for that. But this book here is called Framed. It is not a should read. It is a must read for all women, men, children alike in this country. It is a book that was written and put together by Dr. Christine Cocciola and Amy Pollack. I am the only person in this book that is identified. There are 22 other court stories. It's called Women in the Family Court in the Underworld. I'm the only one identified, obviously, because I had nothing to lose with knowing my identity. Everybody else's names has changed in these books, but there's 22 other stories in here, and there's also people that have, experts that have weighed in and put this book together, and it's an incredible book. It's really it's a must-have for all women and all children, even men alike, anyone that really is in the dating scene, about to get married, divorced, separated, anything. It's really a playbook. And my story is at the end, after the 22 stories, and it starts, unfortunately, like this. I apologize. Some of these parts are a little bit disturbing. So I wrote this testimony. It was a testimony of me, Katherine Sherlock, the mother of Caden, before the Pennsylvania General Assembly, opposing a House bill addressing a child custody in 2019. So this is my story, but I've written it many times, and I've shared it multiple times. We know there was some substantial history between the mother and father, an ongoing custody dispute. I don't know all the details yet, but but we do know it was a very contentious relationship. Captain John Ryan, head of homicide in Philadelphia, stated in his interview with ABC News, not even an hour after my daughter, Kaden Mancuso, was found dead. The story hit news on every channel, heard around the country, even internationally. Cameras arrived at my house. Not even hours later, and the news spread like wildfire. And in almost every publication, the story reported, and always included, the custody dispute and the brutal custody battle. The headlines read, "Child killed amongst custody dispute," and "Father murders daughter amidst custody battle." No one ever actually discussed the details or the issues at hand, that despite his violent past and his threats, he was still awarded parenting time with a little child by the courts, that he was mentally unstable, suicidal, violent, abusive, etc. They just mentioned the custody dispute. In the initial news report, you can see them in the background bringing my daughter out in a body bag, a white one, as my father looks on in utter despair. He insisted on staying on the scene until they took her out, making sure she was handled properly. You can see my husband collapsed on the ground on the other side of the house. Hysterical. You can see white sheets, crime scene investigators, and a medical examiner van, and so on. The brutal murder of a 7-year-old child like it was a scene out of a movie. But it wasn't a movie. It was my new reality. My beautiful, full of life, amazing, gorgeous, talented, smart, spunky, best friend, and all-around amazing daughter was brutally beaten to death by her father. He beat her over and over again in the head with a 35-pound dumbbell, not murdered with a gun as most kids are. But she was found by the door with her shoes on, found by my father and husband. The morning after she should have been returned home, per our court order. She was found by the door because she was trying to get away from the one person who should have cared for her, her own father. I had to tell her at one point during all that we endured that if she ever felt scared around her dad, to run. I needed her to run and call me or the police. Run and run fast because I knew what he was capable of. But despite my pleas, my worst nightmare came true. She was found by the door, beaten to death. He beat her and beat her and beat her and didn't stop until she couldn't fight her anymore. But she did fight for her little life. After he beat her till she thought she was dead enough for him, he flipped her over, tied a wall plastic bag around her head, and secured it with an iPhone charger cord to make sure she wouldn't survive. He then washed his hands, took his time, and to write a 2-page letter as his daughter's lifeless body lay on the floor, and threw it on her dead body. The note stated, "You all get what you deserve." No matter what I told them about how dangerous he was, the courts wouldn't believe me, and they decided this person should have unsupervised parenting time with my daughter because it was her dad and it was his parental right. He then went upstairs, made sure his previously written suicide note was in sight, tied a belt around his neck to the door, anticipated on passing out from the nitrous he had ordered on Amazon that week prior, which was made his body hang itself. He wouldn't feel any pain, and killed himself. This happened over his custodial weekend in August after the judge awarded them to him in May of 2018, denying my request for supervised visits. This happened 18 months after court proceedings started, and to what the media and all the decision makers, including the judge himself, the court system, and the police involved, coined the contentious custody battle. I was the defendant in this case. Court was used as a way to intimidate and control, bankrupt, and punish me. We spent 18 months in actual custody litigation, and many years before we made a court appearance, we had a privately hired lawyers attempting to work this out, attempting to handle the dispute ourselves outside of a courtroom. I trusted the people I hired to help me. I had faith in a system, the justice system, I had no idea about. And they all failed. They failed my daughter, and she lost her beautiful life to do it. I was accused of parental alienation early on from his attorney, claiming that I was alienating, not protecting Kaden, that I was keeping him from her on purpose to be spiteful, because I was a nasty, rotten, spiteful person. And by keeping her from him, he meant not willingly to agreeing to a 50-50 custody agreement. That's how it all started. In the early years, he would show up when he wanted. He couldn't be bothered with actual parenting duties. When he took her, he felt like it, and he did whatever he wanted. If I said no, I was harassed all day. If he couldn't get to me, he'd get to my family, whoever felt was in his path. He never stopped for years. He wanted his way, and no one was going to tell him no. Not a lawyer, not a court, not a judge, not a police. He Googled the term of this bogus alienation theory and used it as a tactic in court to distract from what was really going on. Kaden's and safety and well-being that I brought up in court. I voiced my concerns with the judge over and over again. I begged them to listen to me. I begged everyone to listen to what I was saying, to listen to what Caden was saying. I was trying to get just one person to help me, pleading with my own attorney. I called everyone I thought I could, CPS, police, the courts, the evaluators, the psychiatrists, people at her school, family members, friends, everyone, trying to get somebody to listen to me. I knew what he was capable of. I lived it. He's not physically harming her. There's nothing we can do. It fell on deaf ears. Not agreeing to what he wanted made me difficult in the view of the courts. Statements released by the AOPC, our lovely office, administrative office of the Pennsylvania courts, said that we both had questionable behavior. I am and still blamed for his brutal murder of my daughter. Called every name in the book from people all over the world. Telling me things like, sleep in the bed you made. After Jeff murdered Caden, the judge who had awarded him parenting time released a statement stating, let this toxic relationship and contentiousness be a teachable moment to you all. My child is gone, and the judge can't even acknowledge his decision to award the murderer access to my child, led her to death. He couldn't even accept it.
You've got about 5 minutes, Kathy.
Okay. I've heard from people from all over the world, mostly moms, each one begging me, helping them to share with their own custody issues, asking for advice, sharing stories so similar. I don't want my child to be the next Caden. Tough words to hear. Sadly, I have no advice to give them. What I did in court didn't work for me. I buried a beautiful 7-year-old after spending thousands and thousands of dollars in a system I had faith in. I thought it would protect her. No parent should have to bury their child, especially where it could have been so easily prevented. Parental rights supersede children's rights in our family courts, and this is backwards. Some people are evil and shouldn't have kids or be around kids. You wouldn't have been able to adopt a dog in my state because of his violent history, but humans were fine, according to family law. Caden's father's parental rights superseded her right to live. Every judge, candidate, lawyer, or court personnel I've ever talked to all say the same thing, that the best interest of the child comes first, but it doesn't. In practice, it doesn't.
Kathy?
Yes.
If you don't mind, I know that members are going to have some questions. I'd like to reserve a couple of minutes for that.
Sure thing.
If you
I'm
can.
almost finished. So basically, no parent should have to bury their child, especially when it could have been so preventable. The notes here are, I honored my daughter Katherine by working tirelessly to campaign for family court reform and protection of children. Me and Danielle Pollock and I, policy manager at the National Family Law Center at George Washington University, she's here, saw the efforts come to fruition on March 16, 2022 at the White House. This is where President Biden signed the Reauthorization of Violence Against Women Act, which included the Keeping Children Safe from Family Violence, also known as Caden's Law. This legislation limits the power of abusers to weaponize our family court system against a protective parent and receive custody of children. It must, however, be passed in each state that it has begun. That's how I arrived here in Arizona. And
Okay. I'm going to call time on this now.
Yeah.
Okay.
That's all.
So I have a question. Were you subjected to court-ordered behavioral intervention?
No. We actually, in Pennsylvania, we don't have, I've actually seen it more so now in the past 7 years. We don't have a huge, we call it reunification therapy. That's what they call it. You guys call it Kobe. I hear they've changed the terms over in every state now. They're trying to be tricky. They now call it in California. Where's my,
Yeah, that's what happens when they get
rejoining
found
therapy or something. They went from, because we ban, in VAWA, it bans that part. It says you cannot send people to reunification camps or therapy that we ban that in the 4 points. But say for Pennsylvania, for instance, that part's taken out. Like each state can adapt its own 4 points. So we don't have a huge reunification problem in Pennsylvania, but I can't say that I haven't been at courthouses where people have been sent to these camps. And they're the same people. They're all the same players. And they're getting tricky now, saying that they're changing the wording from reunification to rejoining, trying to get around it. And now you guys are calling it Kobe, so that's interesting to hear.
Yeah.
That they're just changing the wording. And
Well,
it's basically the same thing.
So Kobe's a broad term for all of this
Yeah.
psychobabble?
We call
Yeah.
it reunification therapy in camps. I've had many friends and people sent to these camps across the country. They've been shut down. Some of them have. And the federal law does ban them and the therapy.
Yeah. So, word to other states, and I know that right now we've got about 17 states that have been watching what we're doing here. One of the things that we're very concerned about is substantial noncompliance of the Arizona family court system with federal law. Everybody's got the problem. So, members, any other questions for Kathy? Representative Fink.
Thank you. Thank you for coming. It's heartbreaking to hear the story of your daughter. One of the things that we're looking at is trying to figure out what can be done and what the root cause problem is and how we can address that. From your perspective, what do you see probably one or two of the root causes that is creating this injustice and particularly putting children at risk?
It's basically, it all comes down to money. If you really want to trace it all back, it's $1 billion business in this country. It's a cottage industry. The judges, the players, the CPS, the DIFAS, the evaluators, the reunification people, the COBE people, whatever you want to call them. Why did it cost me so much money to protect my child in a system that I hadn't? There was no other way. I mean, the only thing you can do about domestic violence in this country is to go through the court system, and they don't help you. And you have to, what if I didn't have $15,000 for an unnecessary evaluation that the judge wasn't going to read? Where would I be? I think it comes down to really, people don't want to change. It comes down to the fact that this is costing, and people are making billions of dollars off of this industry. And if they change it, hits them in the pocket, right?
Mr. Chair, one other question.
Ms. Fink?
We have currently here in Arizona the 50-50 clause for parenting time, and you mentioned that Pennsylvania did as well. Did you?
They were trying to. So the thing is if you don't, most people don't end up in family court. Most people work this out on their own. There's and you have 50-50 custody. You don't have to go. It's the most dangerous cases that end up in court. It's 3% actually that they come down, that they end up in family court. Most people don't need to be here. Most people, you would assume you have 50-50. You can just assume that you have it without having even stepped into a court. But they're now trying to put bills in place like the 50-50 bills that makes it harder for victims or people that are actually really do need help to work through that system. And that's where it becomes a problem. More so a problem because it's now going to cost you even more money to get through a presumption or something that's actually already kind of there. Mm-hmm. If you don't have a domestic violence or you don't have an issue with abuse in your case, you guys work it out, you split your house, you go your separate ways, and that's it. But it's what comes down to is it's the 3% of the cases, the most dangerous cases, where nobody's being believed, these kids aren't being believed. They think that these women have magic witch powers that we are able to control. You haven't met my children, but they don't listen to a word I say. Like, I'm telling you, it'd be really hard to brainwash them or get them to pick up their shoes, much less train them to, say, it's just not a thing. And nobody believes anybody. That's the problem. No one's believing anybody. When they do come into these circumstances and they're saying, hey, I'm reporting that this guy's not okay, that something's not right here, they're either hurting, I don't have a, in my case, Kaden wasn't hurt until she was killed, if that makes sense. I couldn't go into court and say he's abusive to her because he wasn't, but he was mentally not stable. That's the aspect I had in my case. But that's not the way it is with most of the people that I hear from probably sitting in this room, that they're disclosing abuse and nobody's believing them. You're not believing kids, you're not believing women, you're not believing men, you're not believing anybody.
So, Kathy, to that point, I heard you say that the judge made a remark that this is a contentious relationship and a teachable moment. Was there a threat assessment done on the biological father?
Yes, we both had evaluations done. One cost $6,000, the other cost $4,000. But the judges don't have to read them. He can make a paper airplane, throw it across the room with it all. For all he can.
And briefly, did the threat assessment of the biological father reveal a danger?
Yep. They noted he was suicidal.
I'm sorry?
They noted he was suicidal in it.
Okay. All right. So that was well known and notorious to the court?
Yep.
Okay.
Yes, that was the thing. We went through all these evaluations. I said, why do I have to pay for these evaluations if you're not even going to read them? The thing is judges don't even have to take them into consideration. So again, what does this look like we're doing here? It's costing. Now, it costs me a lot less money than it costs a lot of my friends to go through court.
Okay.
$15,000, $6,000 for these evals, but the judge, there's nothing in the statutes that says you have to actually take them into consideration. It's good for the only one reason.
No, I
if
understand.
you have an expert like a Arnold Scheinfeld that testifies in your case who sends you to these camps,
right,
the judge doesn't have to listen to him, right? But
Right.
when you have the real expert saying there's a problem here, it goes both ways. That's why we're trying to get real experts in Caden's law, real people with real credentials that have worked through this, not just somebody with
Oh, you
running a
mean people
cuckoo
that follow
camp.
a standard of practice?
Correct.
Ah, yeah.
Yes. As a nurse, I have to, most people professionals do, except for these court personnel that, like,
Right.
you want to come to my house, I'll charge you 15 grand to sing Kumbaya on a camp, but, like, they don't have any licenses. Nobody's regulating it.
Okay.
doesn't
So,
work.
members, any other questions?
I do have one other question.
I
Just real
just want to
quick.
make sure other members have an opportunity to ask questions.
Well, I have it to that point, but she's probably about to cover.
Okay. Ms. Fink.
Okay. I have worked with various parents in the family court right now, and one statistic that was given to me was if the court would listen to the child as to where they wanted to go, that they would be right 95% of the time.
Yeah.
Okay.
That's true. I'm sure. That's a true stat.
Yes, sure.
It's not one of those made up, it's actually probably got evidence-based practice behind it, real studies, stuff like that, facts, science, those things that count, unlike these other things that have nothing. No articles, nothing.
Mr. Chair,
Kitchell?
I have it to that point, to what Representative Fink, her original question to you. So has there been a law? It sounds like someone has presented a 50-50 law in Pennsylvania, but it hasn't gotten any traction yet.
No, we killed that bill.
You killed it. So in that bill in Pennsylvania, did they have certain stipulations that would actually disregard the 50-50, like domestic violence and things like that? Do you remember if that was in the bill?
I don't, because I was just there to testify against it, even though I don't recall. Danielle, who's here, she can probably speak to that, because we've had a lot of them, presumptions come up in Pennsylvania that we've had to testify against. And they're in every other state, too, so like a lot. Like I heard that Kentucky, or Kansas, which is the worst domestic violence in this country, just passed one.
Mhm.
That tells you anything.
Well, because the biggest issue is we're trying to balance that. What's happening is some of our judges are just completely disregarding evidence of domestic violence, and they're calling parental alienation abuse as well. So I guess my warning to you, as you guys look at legislation out there, and we should all be working together nationally on this, honestly, so we're not reinventing the wheels, and so we have some really solid, uniform legislation across the country, because it's all the same in every state, is that we make sure that a judge can't just decide to disregard evidence of abuse based on their whim for the day and put something in there where they're having to record in writing why they're making the decision they're making to put a child with a domestic abuser.
So Caden's law does that.
Okay.
It does do that, but it does it like on the other aspect of it's not the 50-50 presumption. So Caden's law does address that part. You have to put in writing if there's abuse. You have to have like actual evidence, all that, et cetera. I can't really speak on the 50-50 bills because they're usually guys that want to kill me and from Kentucky or Kansas named Kenneth, and I just don't even read their bills. I just know that this is, they'll introduce sneakily underneath of you, and then we have to go and fight them, or whoever has to go and fight them. But I just know they're very dangerous because I don't think they take any of that into consideration. There's a lot to every bill. I don't understand the language of law. My policymaker, she can explain way more than I can. She's the smart one here.
Yeah.
But
That's an AFCC thing. So,
100%
all right.
FCC thing.
Next up is Danielle Pollock from National Safe Parents Organization. All right, I kind of let the cat out of the bag of who you represent, but if you would, give your name for the record and who you represent and where you're from.
Good morning, and thank you for having me today. My name is Danielle Pollock. I am the policy manager at the National Family Violence Law Center at GW Law in Washington, D.C., and I'm also a founder of National Safe Parents Organization, which works all across the country. I'm pleased to be here to speak about the issue of family court and domestic abuse and the perpetuation of violence against women and children, both by litigating domestic abusers and failures of the system itself. And importantly, what we can do about these problems in tangible and viable ways to make it less harmful and unjust for survivors who seek nothing more than to be safe and to keep their children safe and to live in peace. I worked in close collaboration with Professor Joan Meyer, who's the director of the National Family Violence Law Center. I am the originator of Caden's Law, together with Professor Meyer and some other experts. And that was enacted by Congress in 2022 as part of the Violence Against Women Act. It's Title 15. And it's very important to enact these provisions in each state following federal adoption, given that child custody is a state matter. So there's only so much we can do federally. When Congress did this, they authorized $25 million to incentivize states to adopt these provisions to help protect children and improve court practices and protocols in child custody. And I currently provide technical expertise to state lawmakers and stakeholders to bring these provisions of federal cadence law to the states. We have 10 states so far that have adopted it since federal enactment. Regarding my role in international policy development on these matters, I've provided expert consultation to the United Nations Special Rapporteur on Violence Against Women and Girls for her landmark 2023 report to the United Nations Human Rights Council, where she named cadence law as a best practices model for nations to emulate in order to reduce the violence and injustice promulgated against protective parents, who are mostly mothers, and children involved in family court child custody litigation involving abuse. I'm also currently a member of an international work group to advance further research and reforms, together with representatives from the World Health Organization, the World Bank, and several United Nations entities. Regarding my role organizing and educating and empowering survivors and concerned citizens on how to take direct action to create much needed reforms in their state, I lead a monthly live informational session at National Safe Parents Organization, which all members can join, and interested lawmakers if they'd like, press and others. I've also made a short documentary, which Kathy is in, and some other protective moms, and we're working on making a full-length documentary as well. Our work has been covered in the Cover the Wall Street Journal, and that included some reporting on an Arizona case, which you may be familiar with, Tori is the girl's name, involved in a reunification problem. And, you know, turning to what is happening now in family courts to domestic abuse survivors, both adults and children, and some of the reasons why our courts are in such a dismal state, I'll offer a little snapshot. Even though over this series of hearings which you've held, you've had, I think, a pretty good view into what is happening from all the firsthand accounts that the survivors have bravely shared with you all. And I really applaud you for leading the way on this in Arizona, and I've encouraged other states to follow suit to hold these types of hearings so that the public and lawmakers can really understand what's happening in these courts. Caden is one of many children, one of hundreds, if not thousands, who has been murdered by an abuser parent after a court was involved and safety concerns were raised by the protective parent, and custody was nevertheless granted to the dangerous person. This is how Grayson was murdered in Florida. This is how Ohm was murdered in Utah, how Peaky was murdered in California, how Kira was murdered in New York, and on and on and on. It should be unacceptable. This should never happen. Not once, not ever. Especially when the protective parent is bringing evidence of abuse, and it's clear. When these mothers raised safety concerns, they were often accused of lying, exaggerating, alienating, gatekeeping, being hysterical and vindictive, rather than genuinely concerned about their children's safety. The court, and importantly the statutes guiding their practices, too often conclude that it's more important to give the dangerous parent, who's generally the father but not always, his parental rights than to keep the children safe from harm, even when there are clear signs of risk and you know, a history of abusive patterns and even convictions for predatory behavior, as you've heard from some of your testifiers over the series of hearings. We call this pro-contact culture, and let me illustrate to you how pro-contact culture, heavily dependent on this debunked alienation concept, functions in abuse cases, and this is across the country. A mother was so badly abused by her ex, she was placed in the state address confidentiality program where her address is protected so that her abuser cannot find her. But then, over in family court, she is court-ordered to share custody with her abuser, the one she's protected from. That's how serious it is. And she must send her children, her little children, to him every weekend. There, during the visits, this abusive father pumps the young children for information about where they live. He has stalked and repeatedly threatened to kill this mother, by the way, as abusers tend to do sometimes. He needs his parenting time, according to the family court. The children, being too young to outmaneuver a sophisticated and strategic adult abuser, eventually accidentally reveal pertinent details about their house at a visit, enough for him to figure out where they live. The children come home, they're upset, the little girl is distraught and saying she's so sorry because she let some information slip to Dad. The mother is terrified, she tries to hide it from the children, but she's very worried about her safety now because she knows that he knows where she lives, and this is thanks to the court ordering him to have contact with these vulnerable little kids. Days later, she bravely comes to a rally for Caden's Law in front of the Pennsylvania courthouse, which had ordered Caden to her death. And she tells me about this recent turn of events and how scared she is, but nevertheless, she's hopeful because of the advocacy and the reforms coming forward, and she wants to get involved, but carefully. That night, she's dead. She's stabbed to death and beaten in her home. The murder is put on another man, a friend of the father's, and the case is closed. And with the mother dead, the father gets full custody of these children, who previously he couldn't see alone, he had to be supervised, and they're still trapped today. This is pro-contact culture. Even when the father is convicted for such crimes, unlike this father, he still gets custody time. We have a case in Texas. A mother was murdered by the abusive ex, and he was convicted. He was sent to prison. There was no question he did it. The maternal grandmother, the mom of the mother who was murdered, filed to have custody of the traumatized child who was there when she was murdered. But the family court granted custody to the killer's father. And the killer is, while he's in prison, he's permitted ample access to the child via his father. He takes him for visitation there. When he's finished with his prison sentence, very likely he will regain full custody of the child. Father's rights. We have children who have disclosed graphic sexual abuse, things that no child at that age would have knowledge of, but for it having happened to them. But again, family courts over and over do not believe child sexual abuse. That's just the hot potato. They conclude that the mother must have brainwashed the children into believing and disclosing abuse, and buy into this old, she's alienating or lying counterclaim that abusers commonly do in these cases. The children are then court-ordered to live with the sexually abusive father, full custody. He goes on to molest them for years, and their disclosures now fall on deaf ears, and they cannot escape. Who are they going to disclose to? Not the parent they're living with. That person is not going to help them. In New York, a case like this eventually ended in the murder of one of the children, Tommy Valva. The father was convicted for this murder, and in this case, in Tommy Valva's case, the mother tried for years. She had lots of abuse evidence, and the children were starving. They were coming to school dirty and soiled and scrounging in the garbage cans for food. I wish I were exaggerating. You can read it in the newspaper.
Daniel,
Nevertheless,
you got about 5 minutes, and
Okay.
I'd like to reserve some time for questions.
Okay, thank you. Nevertheless, the family court in New York left the children, the boys, with this abusive father, and eventually Tommy was murdered. He's now been convicted, but Tommy is gone. There are many, many other cases I could cite, but I'm sure you're full of horror stories now. I will just touch for a moment on these reunification treatments or camps where supposed counselors are supposed to fix the alienation by, in essence, forcing children to bond with the parent they say abused them frequently. Under the threat, if they don't go along with the program, they will never be able to go home to their safe parent. Their safe parent may go to jail, or they may be put into foster care. So it's scary, kids tend to go along with that. In closing, I will say that, this problem is system-wide. It's not just in Arizona, although there are always pockets and certain districts where it's more problematic, and that's usually because there are certain professionals who are working quite intently and profiting from harming children. 2 weeks ago, I was in Wisconsin bailing out. I didn't pay for the bail. A very generous donor paid for the bail. A Wisconsin mom who was put in jail because her children were ordered to the abusive dad, and one of the children fled to her, and then she was criminalized for just being available to her children, to one of them trying to get safe. And she had a $500,000 bond put on her, and she's facing up to 25 years in prison for interference with the father's custody. So it's very grave. She almost died in jail for the 2.5 months she's been there. Federal Cadence law was developed relying on empirical research about abuse in families and how family courts are responding to it. It targets key areas where courts keep getting it wrong across jurisdictions, states, and countries. These 4 areas are pertain to in-depth, evidence-based training for all court professionals. No junk science theories are allowed in the training. It all has to be normal, empirical research about abuse and what we know about actual abuse in families and how it harms children. It includes training on coercive control, child sexual abuse, perpetrator behavior, sensitivity to diverse populations and cultural sensitivities, which is very important. That's the first part, is the training. The second part is it requires courts to look at all past and present abuse evidence. So a lot of times these courts will say, oh, that happened, 2 years ago, he's recovered. Well, we know that's usually not how abusers perpetrate. They perpetrate over a long period of time. The third part pertains to expert evidence on abuse. You cannot, under Cadence law, give expert testimony on abuse in any form, whether it's oral or written in a report, if you do not have substantial expertise and experience, clinical experience. And by that we mean working directly with impacted populations, so not just forensic experience. And most of these folks who are problematic in these cases only have forensic experience.
We got about 3 minutes.
Okay. And lastly, the federal Cadence law places severe limitations on the reunification treatments ordered by courts. If somebody makes a motion to try to have reunification, they need to first show that the treatment is safe, effective, beneficial, and does not harm any children or hasn't harmed any children. And I would say most, if not all, of these programs cannot reach that burden. So those are the 4 core things that we identified as problems across districts, and Congress enacted this because they recognized it as a very real concern across states. So that's why they created this law and this incentivization. I'm happy to take questions.
All right, thank you very much. I notice in the in section 1602 for Title 15, under legislative and congressional findings, the word empirical is listed a number of times.
Yes.
What I don't see is any footnotes to show what that empirical evidence is. One of the things that we've been battling here in Arizona is this notion of parental alienation. Yet there is not a single definition that makes any sense about that. I mean, you would think that, okay, you have a parent who's alienating one parent to the child, not themselves. Okay, I get it.
Mm-hmm.
And I don't disagree that we have some parents out there that are engaged in a vicious attack on their former partner, okay? What we're trying to get to is a protection of civil rights for the children.
Yes.
And throughout 3 previous hearings, the only people that have talked about the children are the parents who are trying to safeguard them. So
Yeah.
if at all possible, and I appreciate you coming, I would like to have the footnotes for every one of the empirical findings that Congress has listed in the congressional findings.
Happy to provide them.
That would be great. Thank you. The other question that I've got, I've been given to understand that an organization called AFCC is holding seminars all over the country vilifying Cadence law. Now, to me, that's a measure of just how over the target you are on abuse in the court system by individuals who are focused on billable hours, as opposed to rapid, effective outcomes. So we've had testimony in previous hearings about families that have been trapped in a temporary court order for 9 years, and it's cost them over $1 million.
Right.
So What has been your experience, or what is your understanding as far as AFCC goes? And if there's anybody in the audience that's with AFCC, I'd love to hear from you.
Yeah,
Although you probably wouldn't show up here.
I'm happy to talk a little about that.
Yeah. What is your impression and your experience been, or your understanding? What is their beef with Caden's Law in short terms?
Okay. AFCC is a professional membership organization. They are not like the American Academy of Pediatrics or some formal institution that has all of these standards.
They're a trade organization.
They're a trade organization.
Okay.
You pay to be a member. You pay many hundreds of dollars to go to their conferences they hold several times a year around the country. And their interest is to protect the interest of their membership. And that, by that, I mean also financially, right? Mm-hmm. And AFCC has been influencing policy, including custody laws in states, for decades. And this, in large part, is why we are in the state that we are in family court, because the statutes dictating how courts and judges are supposed to decision make in cases, including in cases involving abuse, has been shaped by folks who are not pediatric specialists in abuse, who are not people who understand childhood trauma and the harms and impacts to children across populations, poor, wealthy, all different backgrounds, all races and religions. No, that is not who has been shaping policy for the last 50 years in child custody. It is these interested folks. AFCC is a major driver. It's not the only one. And we showed up at the National Family Violence Law Center and National Safe Parents Organization on the scene because I was determined to change the laws in the country when I discovered how absolutely abominable family court is doing, following rules of evidence and looking at abuse evidence and ordering children into harm's way. And I could not believe it. In so many cases, there's clear evidence of physical abuse, sexual abuse, medical records, children's disclosures, and the court is nevertheless ordering the children to the dangerous parent. It doesn't make sense in any world. And why is this happening? Courts are not properly trained. They're misled into these quasi-theories that encourage courts to disbelieve those disclosing abuse, particularly child sexual abuse. And they are decision-making. Every state custody law has a number of best interest factors. Best interest of the child is supposed to be the guiding principle in child custody decision-making. Well, if you go through the factors, each state has, anywhere from 8 to 14 or 15 factors. The court they have a wide discretion. They go through and they look at the factors. Usually one of them at least has something about abuse. They have to do something with abuse. But one of the other factors we call the friendly parent factor. And the friendly parent factor says you have to collaborate, cooperate, get along with your ex. And if you don't do this, you are a bad parent. You are potentially alienating, or you are the problem. And that is where that friendly parent factor is not the only place, but it's a major place where these folks who have been shaping policy for 50 years are getting in their theories, their illegitimate theories, their unscientific theories to discredit those who are claiming abuse and get children ordered to the dangerous parent, and in many cases, murdered.
All right, members, I've asked my question. I want to give everybody an opportunity. Representative Keschel?
To that point, what you were just talking about, if you had to give us, this room, the number one reason why the courts have gotten so far away from that best interests of the child, what would you say that is as we look ahead to try to fix that?
I would say begin relying on actual abuse experts, not people who are interested in profiting. This is private custody I'm talking about. The litigants are private. The attorneys are all private pay. You don't get a public defender in private custody. The experts, the evaluators, they're all paid out of the pocket of litigants. And this has created a big opportunity or gap for folks who are inappropriately trained, perhaps misguided, and in some cases just malicious and profiteering. And who is suffering? Children. Children and their safe parent. And this has been allowed to happen in private custody because it's not like in the dependency court where at least you have the state who is a party. There are problems in the dependency court, absolutely, in the juvenile courts. But you can sue the state if they do something really erroneous. In private custody, it's very, very, very hard to get accountability. The ways to get accountability in private custody, if you get a horrible decision, is you can appeal. You have to have a lot of means. You have to have a lot of money. You have to hire an attorney. It's very difficult to win on appeal, and you could only win on appeal on a technicality if the court, didn't follow these statutes that are not, entirely influenced by impartial entities. Or, if they really abuse their discretion, it's very hard to show. So you can't get, like this woman who I just went to in Wisconsin, and she's in prison. She lost her children to her admittedly abusive husband. She appealed in Wisconsin. She won. Rare, difficult. She won. She went back to the trial court. She said, the appeals court, your higher court, your bosses said, you made an error. Please fix this and give me my children back. I've raised them my whole life. I've never harmed them, never touched them. I love them. The trial court said, no, you're going to have to do a whole new trial. And we're still, in essence, they were suggesting that they would keep the children with the father. She was depleted, her resources, and psychologically. They kept the children with the father. And so then she fled. And then now she's criminalized.
Yeah, so to that point,
Yeah.
this all traces back to one undeniable fact. The center of the universe in the family court order system is billable hours. It's billable hours for the attorneys. It's billable hours for the psychologists, the psychiatrists, the advisors, the supervisors, everybody in that system, and all the while they have quasi-judicial immunity.
Yes.
Can you tell me, within Caden's law, was quasi-judicial immunity a part of that effort? And the follow-on to that is, if we had a standard of practice that locked people down into what they can and can't do, we wouldn't need quasi-judicial immunity.
Yeah.
And by the way, insurance companies would pay for that because there is actually a standard of practice that you can pin the tail on the donkey. So, in Caden's law, was there any mention of quasi-judicial immunity, either abandoning it, limiting it, or outright putting it to death?
No, but we absolutely recognize that this is a crucial issue, and it's something that has to be handled state by state. And so some states have brought cases to the higher courts to try to remove this quasi-judicial immunity for these third-party neutrals, these custody evaluators and guardians. And a handful of states have just, Pennsylvania being one of them, has just won an important case to remove that immunity from guardians.
Yeah, I'm
But
sorry.
it's-
Did you just use the term quasi-judicial neutrals?
Immunity, no, third-party neutrals.
Third-party neutrals. Well, they're anything but.
Yeah, well, that's
Yeah.
right, and that's part of the problem because courts are abdicating their decision-making power to these people who they imagine to be neutral and very highly qualified, and in many cases they are neither.
That's
They
exactly
are
what
always
causes
getting
us
paid.
distress on this panel, ma'am.
Yes.
All right. Members, any other questions? Ms. Fink.
Yes, thank you. Thank you for coming. I appreciate it. I'm just going to kind of repeat my question from before.
Okay.
Because in regards to children, the children aren't being listened to. So if the children were being listened to, because I've tried to put in a bill, 14 years of age, but that wouldn't have helped out Caden at all.
Right.
So with that, how can, would you say that, again, if the courts would actually listen to the children, and if they did what the children wanted, that 95, 99% they would be correct?
I would say in the overwhelming majority, yes. There is a concern that, some children are so terrified by the abuser, and, they say, if you don't say you want to live with me, I'm going to kill mommy, or I'm going to do these terrible things. So there are cases that are outliers, but on the whole, on general, kids can absolutely express who they prefer, who they feel safe with, who they want to live with, how they want their lives to look, and including young children. I mean, I tend to prefer that there's not an age put on that. I mean, some states say, you know, the age of reason, and some states put a specific age. But little kids can express that. I mean, I've seen little kids who are being sexually abused. They're terrified to go into the visitation room and sit on daddy's lap and color with him. They beg, you know, to be let out and cry and sob. They're saying, they're like 3 and 4 years old, and they're saying they're trying to get to mommy. Mommy, don't leave me. I mean, it's not difficult. I mean, the other thing that you can write in a bill is when a child is expressing fear, explicit fear. This is generally a very clear way to know that a child, in cases even when children are nonverbal sometimes, right? They can indicate these things. And if you have actual abuse experts assessing what kids are exhibiting, you can get that information into courts. The problem is the actual abuse experts, the pediatricians and et cetera, it's hard to get them into courts. We also have therapists who are clinical therapists who are treating children, and they many times get pushed out of treating the child once a child custody case starts because they want the therapist to be one of their alienation folks, right? And so then they come into the case and they start to nudge out the actual child therapist who really does have the child's interest. They're treating the child for trauma or for whatever the child is upset about, you know, bedwetting or nightmares or whatever it is. And that person, who's an actual clinical person, could come and testify to the court and give valid information about what is going on with the child, what the child wants. The other thing about the child's voice, which is very important, is the idea of guardians ad litem was, you know, came on in the 90s. And the idea was, we're going to protect children from litigation because that's bad for them. And we're going to have this neutral person represent the voice of the child who's an adult and who's not well trained. And the theory was good, right? Yes, you know, we don't want kids in court all day long. But what has happened is that these guardians, many times, they're no more knowledgeable than the postman. And some guardians are great. I don't want to, you know, some people really are genuinely, their heart is in the right place and they do care deeply about children. But many of them are just inappropriately qualified, and many of them are paid. And what's happened with guardians is, instead of getting the child's voice to the court, they end up suppressing the child's voice many times and misrepresenting what the child says. We have countless cases where the child, after the case, you know, they say, I told them, you know, I'm getting hurt, I don't want to go to his house. And then the guardian goes back to the court and says, you know, we think it's best for the child to go to both parents. And that's because of the way the statutes are written in many cases, because it's ill-defined what the guardian's role is. But generally, a guardian ad litem is supposed to represent the best interest of the child, and that, again, opens it up for discretion. In contrast, if you have an attorney for the child, instead of a guardian, they are supposed to represent the child as a client. And we advocate for this model because they really, you know, it's, if the child says, I want to live with mom or I want to live with dad, the attorney for the child is obligated as the attorney to go and tell that to the court, unlike a guardian ad litem whose best interest is the guardian's opinion.
Thank you. So there's this term thrown around here a lot, forensically informed. That sounds like croutons on word salad to me. And that is something that we're going to get to the bottom of and try to write legislation that properly defines that and properly defines the role of individuals who are involved with the court. So, members,
Yeah.
we're already over time. And Danielle, if you can, I know you and Kathy need to catch a flight home. But if you can stick around for a little while,
Sure.
We've got a matter of housekeeping that we need to break from family court orders and listen to DCS for a couple of minutes.
Okay, sure.
And then perhaps we'll have you come back up, okay?
Okay.
All right,
Thank you for
very much.
having me. I really appreciate it.
Okay, so we've got somebody here from there. We're only 3 minutes late. Arizona Department of Child Safety. If you would, please give your name for the record. And it looks like on the calendar you have about 25 minutes, so you have 21 minutes now.
All right, I might be able to stay a little bit longer if you need me.
All right.
Good morning, Mr. Chair, members of the committee. For the record, my name is Katherine Patak. I am the director of the Arizona Department of Child Safety. I've been asked to come here and present for about 15 minutes on our statutes, our authority, and how we interact with the family court. So here's our statutory authority. You can see our purposes in 8451. The primary purpose of the department is to protect children, and then we are to do these 4 things equally: investigate reports of abuse or neglect, assess, promote, and support the safety of a child, work cooperatively with law enforcement, and coordinate services to achieve and maintain permanency on behalf of the child, strengthen the family, and provide prevention, intervention, and treatment services without compromising child safety. I also have, I've listed here how we're able to take temporary custody of a child. We can take temporary custody of a child one of 3 ways. The first way is through an order of the court. The second is exigent circumstances, which means the child is unsafe right now, and if I don't act in the time it takes me to get in front of a court, the child will be seriously harmed. Or the child's parents or guardian can consent to us taking custody. I've cited here to our initial safety assessment and investment protocol. So this talks about that we have to have a safety assessment guide. It's in statute. I'm going to get into what that looks like and how we use it. And then we also here in 8-809.01, we have parents and guardians' rights. So parents have the right to be informed of the purpose of the investigation. They have the right to refuse to cooperate with an investigation. They can deny us entry if they choose, unless a court order grants us permission. And they also have the right to seek advice from an attorney or have an attorney present. So this is dependency case jurisdiction. So juvenile court, which is not family court, they are 2 separate things, has exclusive original jurisdiction over petitions to take temporary custody of the child and to terminate the parent-child relationship. Family court has jurisdiction over things like marriage, custody, divorce. DCS can investigate when ordered by the family court if the allegations rise to the level of abuse or neglect. We also will provide evidence to family court for investigation. So for example, if we are investigating, we find one parent is safe, so we are not going to take custody of the child, but that parent wants to use that information in family court. The family court can either order or subpoena the records. They can order the caseworker to show up, and so we can do that. So our case process, it starts at the hotline. All cases of abuse or neglect have to start at the hotline. So a call is made, or mandatory reporters can use an online reporting system. We receive about 160,000 calls every year to our hotline. About half allege abuse or neglect. So half are calling and saying, who's my case manager, where's your office, those kind of things. The other half, about half, meet statutory criteria. So in order to meet statutory criteria, the allegation of abuse or neglect has to be against a parent, guardian, or custodian. We don't take reports on teachers or neighbors or child on child, unless the allegation is the parent is failing to protect from that. It must be against a child victim. The child has to be present or a resident of Arizona, and the alleged abuse has to constitute abuse or neglect. So it has to meet the statutory definition of that. That requires either an allegation of harm if it's physical abuse, or a substantial risk of harm if it's neglect.
Excuse me, to that point,
Mm-hmm.
I noticed here, neglect must allege a substantial risk or harm.
Yes.
Would that include a parent driving drunk or high with the child in the vehicle?
Mr. Chair, yes.
Okay. Okay, thank you.
The example I like to give that I think is helpful, if I call the hotline and I say, my neighbor smokes pot all day long, he has little kids, right? There's no allegation of harm to the child. If I call and say, my neighbor smokes pot, he has little kids, the kids are in diapers in the front yard, they're unsupervised, then there's a risk of harm to the child, right? And that's when DCS gets involved.
Okay, now you've confused me a little bit.
Sure.
So you're saying that if a child, I mean, the Surgeon General says smoking cigarettes is bad for you and you shouldn't have secondhand smoke.
Sure.
Okay, to what, how far do we go down the rabbit
Yeah.
trail of exposure by an adult
Sure.
to a child? Frankly, you have a household that's filled with pot smoke, with all the empirical evidence that says that is bad for the childhood's brain development. I mean, where do we
Sure.
where are we going here with
Mr.
that?
Chair, I gave that, maybe that wasn't the right example. Let's say, right.
No, maybe it was the right example.
Sure,
We'll have to look
sure.
at that.
In my brain,
the child's not being exposed to the smoke. Maybe they're doing gummies, right? Something like that. So the child's not exposed. Like if they say and the child's in the room while they're smoking, then there's a risk to the harm, right?
Okay.
So there has to be a tie to and the child's unsafe.
Okay.
Okay.
Fair
Is
enough.
that better?
Fair
All
enough.
right. Sorry.
I know you were going after the dirty diapers and no food in the house
I
thing.
was going
okay.
after that.
Got it.
Okay.
Chair, to that point,
Yes, Senator.
thank you. Thank you. Thank you very much for your information. When you talk about there being not a direct risk, if the person popping gummies, you don't know if those gummies are laid out on a table and the child could very well see, wow, gummy bears.
Yep.
You know, how is that not a risk?
So, Mr. Chair and Senator Hatoffoli, the point I'm trying to make is that there has to be a tie to it. So if they say the gummies are out, the kids have access to them. And the hotline, if any of you want to come see the hotline, you should. You can sit in, you can listen to a call of how they take them. It's a script, so they're going to ask those kind of questions, right? They're going to say, does the child have access to them? Are they out? Is there a safe caregiver? Maybe grandma is in the home too, and grandma watches the kids while they're, doing their stuff, right? So I gave a very simplified example, but the hotline's going to ask those kind of questions and draw some of those things out.
One more question, please.
Please, go ahead.
Thank you. Thank you very much for that information. And I know things can change with each situation. I understand that. But statutorily, you stated that there is a definition for physical abuse and neglect. I would be very curious as to know what that definition is and how that relates to the threshold of harm, which normally is the jargon presented when a child may be in danger or if there is no response or reason or justification for investigation.
Sure. So, Mr. Chair and Senator Hatoffoli, so the definitions are in 8201, abuse, and I've worked for DCS for a long time. I don't have them perfectly memorized, but physical abuse has to be an act by a parent or caregiver plus an injury in kind of general terms. That's physical abuse. Sexual abuse is something different. And then we have neglect. And neglect, there's a lot of categories under neglect. The general category under neglect says the unwillingness or inability of a parent, guardian, or custodian to provide the child with things like supervision, medical care, food, those kind of things, if it causes a substantial risk of harm to the child. And then there's some other things like a substance-exposed newborn counts. There's things like if you're making dangerous drugs in the home. Like there's a couple other categories underneath it that I don't have all of them memorized, but they're all in 8201.
Thank you.
Okay, so these are the numbers I talked about, just so you can see them. So like the tan line is not alleging abuse or neglect. Green is alleging abuse or neglect, but it doesn't meet report criteria for one of the reasons I listed. And then the orange at the bottom is it meets report criteria, and we're going to investigate those. So you can see we investigate between 2,000, 3,000, 4,000 cases a month. You can see it's cyclical. So April is Child Abuse Prevention Month. Our reports go way up. The summer, school is out. Our reports go down.
So this is a call volume report.
This is our call volume. Yep.
Okay.
This
All right,
is
thank
total new and closed reports. You all should keep a very close eye on this because some of you probably remember we had the backlog of uninvestigated cases that at one point was 36,000 uninvestigated cases. You can see now it's about 7,200 in August, and that is about where we should be based on the number of staff we have. That's the amount of work we can get done in a month. So we try to keep it right between 7,000 and 8,000. You should keep an eye on these numbers because green is closed, orange is open. If for month over month the orange goes higher than the green, then you need to ask me what we're doing to make sure we're not getting back into having too many opened cases. So
if we
yeah.
could we go back to, just for a moment, defining harm? Is it a physical injury? Is it a psychological injury? I mean, we got a lot of kids out there that are now being reported having PTSD
Okay.
because of what they've been subjected to, not only physically, but psychologically. Can you help me with that a little bit?
Sure. So, Mr. Chair, emotional abuse is a separate category, and
enough.
you're working my recollection right now. So
Yeah,
that
I guess what I'm trying to get to is,
It-
do we have a unified definition of harm?
So under the neglect definition, it just says substantial risk of harm. It's not there. Emotional abuse is something that's separate and has to be defined by, or has to be diagnosed by a medical professional.
Okay.
So those are two separate things.
All right.
Okay. Okay, so contact with our family. So all of our investigators have to be trained in forensic interviewing and the process and protocols. The training must include evidence-informed safety assessment model, which I'm going to get into. That's how we make our safety and removal decisions. The duty to protect the legal and due process rights of the children and the families. They have to be trained on a child's rights as a crime victim. We have a whole victims' rights unit of children who are victim of crime where we help them through that. And then it has to have a checklist or other mechanism to assess them and giving consideration to the relevant factors. So that's what I'm going to talk about.
Excuse me.
Yep.
So, tell me a little bit about your investigators being trained in forensic interviewing. There's that word that pops up again. Forensically informed. Are you talking about classic law enforcement forensic instruction?
Yes, Mr. Chair.
All right. So
Yes.
this is the kind of stuff that a criminal investigator like myself would have gone through.
Mr. Chair, yes.
All right. Thank you.
Okay. And then we also have our Office of Child Welfare Investigations. So they have to either investigate or touch any case that alleges criminal conduct, which is, if true, it's felony child abuse, any type of sex abuse. So they are a specialized unit that has even additional training. They work specifically and do joint investigations with law enforcement to make sure that as we're doing our piece, if there's a criminal component to it, that we're not impacting the criminal case, and both are able to move forward. We also do it because it's traumatizing for children to be interviewed about their abuse, and we don't want to have to interview them. We interview them, then the police interview them, then the hospital interviews them, right? We take them to Child Help. We do it all kind of at once.
Excuse me. Let me go back to the forensic interviewing instruction. Who does that?
Mr. Chair, I would have to ask. I know they do it in their core curriculum training. So we run it, but I don't know who designed it. I would have to find out.
No, let me reframe the question. Is that done out of the School of Social Work at ASU? Is it done by a post-certified instructor? I'm looking for
Yeah.
who is training these people, because that's going to, I think, reveal a potential bias. That's kind of where I was going with
Sure.
that.
Mr. Chair, I don't know that off the top of my head. I'm going to have to get you
All
that
right, if
answer.
you would, I'd like to find that out.
Mr. Chair, and I have kind of a follow-up or to that point. How long is the training?
Mr. Chair and Representative Keschel, the training is 22 weeks. So they're in the classroom, I believe, for either 4 to 8 weeks, and then they go out into the field and they're trained with, like, they have a supervisor who assists them. So they don't take on a full caseload for 22 weeks.
Okay, so I'm sorry, Mr. Chair. So to that point, the in-classroom training is 4 to 8 weeks. Where is that 4-week discrepancy coming from? And then the rest of the training is just in the field, kind of as an apprentice to a caseworker? How does, I guess I need more clarity.
Sure, Mr. Chair and Representative Keschel, I'm not remembering off the top of my head. I believe it's 4 weeks in the classroom. And so they're doing things like we're talking about the laws, how to show up in court, how to interview a child, all the kind of social worky type things. And then an apprenticeship is a good way to describe it. So you're shadowing under somebody in the office. So you're.
Okay, and one more, Mr. Chair, sorry. When they're learning laws, are they talking at all in this training about constitutional rights of parents and kids?
Mr. Chair and Representative Keschel, yes, they are. And our Attorney General's office also does a training for them on those as well.
All right. Ladies and gentlemen, we can't have that, okay? I've been pretty tolerant of applause, but this is about fact-finding. We're trying to be neutral collectors of information. So please, let's control ourselves. If you want to get excited, go out in the plaza, okay? I'm a little distressed over the closed reports piece.
Okay.
A 10-year-old young lady by the name of Rebecca. Died on July 30th after 12 reports to the hotline. So when I see a graph that says closed reports, with all due respect, man, that doesn't tell me squat. I would like to know, and maybe you can't answer this question, and it's fair if you can't, how many of those 12 reports were closed? Or did all 12 remain open? And
Mr.
I'm-
Chair, are you asking?
Like
at
I
the
said, don't guess.
No, I'm not guessing.
I'm fine with an answer if you need to go back and research it.
Sure. Mr. Chair, are you asking at the time of her death, how many were open or closed? Or just
So
in
there are
general?
12 hotline reports concerning Rebecca. How many were closed? How many remained open until the time of her death?
Mr. Chair, there was one open at the time of her death, and
So-
it was the final one we had received.
Okay, so there were 11 that were called and closed.
Mr. Chair, yes, and yes.
Okay. I didn't ask the question to make you look bad.
Sure.
I'm trying to understand
Mhm.
internally the process of closing cases.
Mhm.
If it's a staffing issue, if it's a, hey, we're getting near the end of the month, we got to close out reports so that we meet a number. I'd like to think that these are legitimate investigations before cases were closed or reports were closed. But Rebecca's case is disturbing beyond description. And I'd like to know, how many other cases are there like this that we've got multiple reports that revolve around the same child that are either open or have been closed without taking action? Now that's a huge question, and frankly, I don't think I'm going to have you answer it here.
Okay.
As you probably already know, DCS is about to be audited by the State Auditor General at some point in the not too distant future. That'll be something that I am going to ask the Auditor General to take a close look at, so that you've got forewarning, okay?
Mr. Chair, would you like me to go through how we respond to events like that and what we've done in response to it?
Hold that
or-
thought for
okay.
just a second. Did you have it to that point, Representative Keschel?
Mr. Chair, I do. I have a follow-up to you because I have here a list in my hand with Rebecca up top of kids that have died in DCS custody. And I guess because we need to work together. There are, what I've learned is, especially between the family courts and DCS, I've talked to Chris about this, there is some of the DCS caseworkers going, oh, family court, I'm not touching that. That's a problem because there are kids that are really in danger. And one dead kiddo is one too many. And this is happening because of both DCS and family courts. So I guess how do we balance, because I have a couple of dads I've met here today that are going to talk about being falsely accused. So the ex-spouse is throwing false accusations at these people sometimes, which I know you guys see. I will give you the benefit of the doubt with that. I know that happens. That some of these co-parents, if you want to call them that, have learned how to use the system to continue to abuse or retaliate by false allegations. Is there anything we can do with you guys to help kind of close that gap?
So I think, Mr. Chair and Representative Keschel, I'll talk a little bit about how we respond to cases where a child is killed and we had history, because it's going to answer your question. So it's easy for me to look at the case and say, well, I have a question here, I have a question here, right? I mean, there are things in the case that I look at, and I am probably having this similar reaction to what you are. But I need to understand why staff made the decisions that they did, because it could be, was it management saying you need to close cases quickly because we have to, right? Is it that is influencing behavior? Is it we have a tool at the hotline that I'll talk about, how we screen cases in and how we screen them out? Did we mess with the tool and it did something weird? You know what I mean? Like, I need to understand why staff made decisions that they did. Was it that they know the family and they knew the dad and they were like, we know that, you know what I mean? Like, I don't know the answers to those today. So we do, we have a multidisciplinary team. They involve members of the public. It has law enforcement on it. It has a pediatrician. It has a child's attorney. And it has DCS staff. And what we do is we present to them, here are things in the case that seem odd to us. I'll say they seem odd. They've listened to every hotline call, screened in or out. They have reviewed the hard paper file. And they're going to present this week to the team. Here's where we have questions, and how would you advise us to move forward on this? So we're getting outside perspective on it. We use a third-party contractor to help us do this. And then we debrief the staff and we say to staff, we're not HR, we're not your boss, we're not here to get you in trouble, but I need to understand how you made this decision, because that's how we make change, right? If it's a policy, they say, well, I followed the policy. The policy told me to do this. Okay, then we change the policy. But if they say, well, the policy is fine, but you all told us we have to close our cases and we felt pressure, then that's what, you know what I mean? That's what we change.
That's
Because
a management thing.
I don't want to point and say, fix this, if that's not going to solve it, right?
No, fair enough. So I'm aware that you have a 10:30 hard stop.
I can stay until 11,
Okay, well, hopefully.
but then I have to go.
How about we wrap this up in
You want me
like
to
the
start
next
talking
7
quickly?
minutes?
Okay. I'm a fast
'Cause
talker, but I'm
you-
not that.
You might have
I'm not that
noticed
fast.
there's a gaggle of people behind you.
I see that, yes.
That are all here to speak.
Okay.
So.
So I'm going to talk about our safety decision-making model, because it sounds like this is something that you all are having questions about. How do we make safety decisions? Okay, so we have a tool. The tool is to make the right decision for the family in front of us, not using influences, outside influences, some of the stuff I've said. The purpose is to identify if children are unsafe, right? Are they safe? Are they unsafe? Determine who they're safe, unsafe, figure out how to protect them if they are, establish safety plans, and then figure out how we make sure it doesn't happen again. So when I go out, the field goes out to a family, we've received a hotline report, we have the allegations, they should be looking at all of the history with the family we've had. They're going to make a present or impending danger assessment. So present danger means this child is unsafe right now, and I have to act, or the child will be harmed. Okay, so that is present danger. There are 19 present danger conditions. I have them if you want me to go over them, but they're clearly defined, they are immediate. It has to be happening right now. I have to be able to see it. It's not a gut feeling, I have to see it. And it has to be significant to the child. So those are generally what we look for present danger. Most of our cases are impending danger, so the child is safe right now, but we're concerned they're going to be unsafe in the future. So we have 16 impending danger descriptors, which I also have. It requires the field to do a thorough collection of information regarding caregiver function and protective capacities. So when we talk about parental protective capacities, that's emotional, cognitive, and behavioral. Are they able to protect the child? There are 6 domains of family functioning that I can go into if you want me to, but we have all this. And then there are 5 safety threshold criteria. So if I go into the home and I see something, I see dad is smoking pot all the time and the kids around. Okay, we'll use that example. It has to be something I can see, it's observable, I can see the whatever out. The child has to be vulnerable. So if the child's, not in that example, but if the child's 16 versus 3, right, we're going to have to behave differently on how to protect the child. It has to be unmanaged. It has to have a severe effect to the child, and the harm has to be imminent. So it has to be reoccurring. It's going to happen again. So if that's when you have a child who's unsafe, if all of those things are met. So once you have a child who's unsafe, you have to safety plan. Removal is the last option. So these are the order we go in. So can the threatening person leave the home? Can the protective parent and child leave the home? Can a responsible adult help? Maybe the issue is the parents go on a bender every weekend and get really drunk and the kid's little. Can the kid go to grandma's house on the weekend? Then we don't have to intervene. You know what I mean? Can we put in some sort of help for the family where the department doesn't have to get involved? If we decide none of those are going to work to keep the child safe, out-of-home care is necessary. We get a court order to remove the child. The worker doesn't make that decision alone. They have to staff it with their supervisor. The judge will reaffirm or modify placement decisions. Our placement preference is in this order with kin, so family first. If that doesn't work, we want a community foster home. We always try to keep the siblings together whenever possible. Next is congregate care, which is not a preferred option, and then residential facility would be like a behavioral health treatment facility if the child needs that level of care and is ordered by the court. 77% of our kids are in a family-like setting, whether in a foster home, community foster home, or kinship placement. In almost every case, last time I checked, I think it was around 94%, the initial goal is reunification. So this is where our kids are placed. It's what I just said. So about 46% are with kin, so that's somebody who's known to the child. 30% are community foster, and about 20% are in a group home. So case planning, when a child is in out-of-home care, the parents get an attorney. They're assigned an attorney. The services are paid for by DCS, whatever services the court orders. They are aimed at helping the parents make behavioral changes to keep the child safe. It should not be compliance-based. It shouldn't be you took 10 classes, you get your kids back. It should be you've taken the classes and you've shown you can make the behavioral changes to keep the children safe. When we remove the children, we give them conditions for return. So we say if in order to get your children back, you have to have made these changes. You know, we tell them what we need to see in order for the kids to get back home.
I'm sorry, who's making those assessments?
So so it should be done in a team decision-making meeting, which is DCS. They're facilitated not by the caseworker, but by someone who's trained in meeting facilitation. So it should, in practice, it should be in conjunction with the family. The family supports. If grandma's a support, grandma can be there. Their attorneys often participate.
Okay, you said in practice, that sounds like in theory.
In policy, that's who should be there,
Okay,
and it should
policy
be right. It
is
should
theory,
be.
practice is different.
Right. I'm sure you're going to have people who are going to tell you that's not what happens. So I don't want to say in 100% of the cases that's what happens. That's
Okay,
how it should, right? That's how it should happen.
Yeah, I guess the source of my question is, do we have a medical doctor assessing for a psychological issue? Somebody who's not, do we have a mismatch in the people who are doing an evaluation?
So, Mr. Chair, it would depend on what the court orders. We usually, depending on what the allegations are. So if there are no allegations the parent has mental health issues, we shouldn't be ordering that as a service, right?
Okay.
But we may get a court order for a psychological evaluation, which will then help determine what services the parent should participate in. But we would pay for that.
Okay, would it be fair to say that your forensically informed investigators have the opportunity to have a moment of first impression to say, you know what? I guess the question is, do they have the freedom to tell the court, something's not right here? And it's not physical.
Mm-hmm.
There's either an emotional issue with one of the parents or a psychological issue with one of the parents, and it's presented in a way that gives rise to concern. And I get policy-wise, you got to walk a really thin line on, because it's not illegal to be a bad parent.
Mm-hmm.
It is illegal.
Mm-hmm.
It's not illegal. It is questionable
Mm-hmm.
for a parent who engages in behaviors that are abusive in any way, shape, and form, whether it's physical, psychological, emotional, the whole gambit. Okay? I just want to know, is there a way for one of your field agents to say, I've got a question about this for the interest of the child?
Mm-hmm.
And then the follow-on question on that is, who pays for that?
So, Mr. Chair, emotional functioning of the parent is something that we assess in our family functioning assessment. So it is
Okay.
something that we look into.
Okay.
Some of the safety threshold factors describe that. So like one of them is the child is profoundly fearful of a parent, guardian, or custodian, or somebody who has access to the child. The child can describe the threats. They seem reasonable, believable. They have fear of retribution or retaliation. Some of them have to do with like erratic behavior, those kind of things as relate to the parent. So those are contemplated in our family functioning assessment.
Okay.
Mr. Chair? I have a
Representative
question.
Fink?
Thank you. Thank you for coming. In regards to this case planning, because I have had many different family court cases where DCS has come out, and yes, there is, evidence of abuse, and yet DCS says they're not going to do anything and allows the child to go back to the abusive parent. And so, but here you say you have a case planning process.
Mm-hmm.
Where does that fit?
So, Mr. Chair and Representative Fink, this I think is the crux of the issue, right? We don't take custody of a child when there's a safe parent. So I knew you were going to ask me this question, so I looked up the statute. So a dependent child, which means they're in our custody, is defined as there's no parent or guardian willing or capable to care for them. And I think this is where a lot of the questions come up, because we investigate. We say, Mom, you're safe. Dad, we don't believe is safe. But we can't take custody just from Dad. Right? That's not a thing we can do. What we can do, and what we've been working with the family courts to do is to help get our information to the family court, because we've interviewed the kid, we've interviewed the parents, so we may have information that's helpful. Our workers frequently testify in family court about what they observed or what they saw. We provide documents, and we're figuring out a way to get documents quicker, because as we said, that some of these temporary custody hearings are in a couple days. So we've worked with the courts to say, don't ask for the whole case file, right? Because the whole case file could take 1,000 pages and take a month to get you. But if you ask for these 3 or 4 documents, they're going to get you the information you need, and we can do it today. So that's what we're trying to work with the courts on, to make sure that they have the information where we're not able to act, but we have information that's helpful, right?
To that point.
So we've got about 5 minutes left.
Okay.
Go ahead.
I'll go ahead.
Okay. I guess, and I want to let you get through the rest of your,
Okay.
you're going to have to steam through it pretty fast, but I do have a question. So you get federal funding to reunify under Title, I think it's Title 5, or Title 4E and Title 4B. So Congress now recognizes in their findings that reunification with an abusive parent is detrimental to the child. So I'm thinking it sounds like we need to have a policy adjustment at the very least, if not a statutory revision. Can you speak to, just momentarily, how much money comes in to DCS from the federal government for that purpose?
So, Mr. Chair, the money isn't specifically for reunification. So once we've removed a child and they're in out-of-home care, we can use federal funds. It's a match, so we have to have state dollars attached to it for particular things. So sometimes it's services to parents, which is what you're talking about, reunification services to parents. And sometimes it's for the child's placement. Sometimes it's for, we can use some for administrative costs. We use it for a variety of different things. What the law says is, in order to sever a parent's rights, which means we're not returning the children, certain grounds have to be met. So there are a couple that we can do right away. So kid comes into foster care, we say, you're not getting your kid back. What you did is so bad, you're not getting your kid back. That is few and far between, okay, because they're serious things. Generally, we can only sever parental rights if a child has been in out-of-home care and foster care for a certain amount of time. We have tried to reunify, because that's what the law requires, that we give you services to make you a better parent. You have failed to make the behavioral changes, then we can sever your rights. So if we don't attempt to reunify, then we don't have a ground to sever their rights. And that's federal, that's state, it's everywhere.
Okay. All right. So in the 4 minutes you have left, get to the most important stuff.
Okay.
And I'm sure we'll have an opportunity to review this again.
Yeah, of course. Okay, so I was just going to talk about some of the services we give to the parents. So the juvenile court can order the services. Parents, they don't have to comply, right? We don't make you show up to therapy. The services can include visitation. It almost always includes visitation. It's generally supervised at the beginning. So you'll have somebody watching the parent interact with their child. At some point, if the parent is participating in the services, making the behavioral changes, we can shift to unsupervised. It's often parenting classes, sometimes it's therapy, sometimes it's drug or alcohol counseling. We pay for all of this. Parents can use their own insurance if they want. If they say, I have a therapist through my church who I want to use, we allow that. If not, we're going to pay for it. If the parent is out of state, if the parent is incarcerated, we will still do those services if they're ordered by the court. It depends on what they're incarcerated for, obviously. And then if the child, like the grandma lives in Indiana and we want the child to go live in Indiana, we'll pay for, it's called Interstate Compact for the Placement of Children. We'll pay for the services interstate so they can still have visits and all that kind of stuff. And then I knew we were going to get to this. So we don't have authority to remove from one parent. So we'll say, you have to deal with that through family court.
Okay, I have a question,
Representative
Mr. Chair.
Katherine.
So on the money issue, what do your caseworkers make? This is just something I don't know the answer to. I don't think it's very much.
Mr. Chair and Representative Keschel, no, they make about 55 is where they top out. So we've done a couple things to try and incentivize when people leave, because turnover is a problem, and quite frankly, I think that's something we may learn from this Rebecca case, is that you have new case managers coming out and maybe they're not as seasoned or well-trained as some other, not well-trained, but, they're not as seasoned as other caseworkers. So we give them a pay increase when ASRS kicks in, because if we don't, then they're actually making less money than they were to do the same job. Their paycheck is lower. We give them a pay increase at 18 months, because that's when we see a lot of people leave. But they top out at about $55,000.
Okay. And I just have one more, Mr. Chair. I could ask you questions all day. I have so many. But one of my questions, because you vaguely touched on your experts that you use. Are there any experts that are being utilized, I call them experts very lightly, that are being utilized in both the juvenile courts and the family courts, or is that a whole separate entity? Is there anybody that goes back and forth?
Mr. Chair and Representative Kishel, that's a good question. So I know some of them have court contracts, so they could. I don't know. I'll find out, okay? And I'll get you more information about the training too. I'll make sure we get you the right stuff.
That's it. Thank you very much. I appreciate it.
All right.
I know you've got to get going. I'm sure that this topic is not going to go away. We'll have an opportunity to talk more. Okay, we're going to get back on the family court orders piece.
Okay, so our first, well, it's actually a lot of the speakers I have, Mr. Chair, have to do with both, so that's really helpful. So first speaker is Michael Moore.
Chair?
Yes, Senator.
Yes, for the record, I'd like to make a statement regarding the last presentation.
Okay, yeah, please.
Yes, for the record, I just wanted to make a statement that the reports that are mentioned in here are specifically those children who are under DCS care.
Mm-hmm.
And so when they have these reports open to that, those reports by statute are provided to the Senate President. And so our constituents come to us with these issues. And so that's where we find a discrepancy. And not only has this happened even more recently, for my constituents, I've had situations where these licenses are managed and approved and provided by DCS for children, but they have indigenous children in those. And so many of them are not part of this reporting process. But these children are in those homes. Mm-hmm. For example, 2 years ago, there was 2 Native American girls who ran away and their bodies were found in a pool of water. And I've been asking for results. I've been asking what has been done, how has the system been improved. I was told by, and I did meet with the director as well as Chris, and it was communicated to me that I don't have access to that information and that I would have to go through Senate President Peterson. So the reporting that we see I think there's discrimination in that. And if they are in these group homes or foster homes that are licensed by DCS, those reports should be included. For example, Emily Pike, she's not included in these reports, but she was in a group home that was licensed by DCS.
Well,
so I just wanted to bring that to light.
Thank you. But to that point, one of the reasons it goes through the Senate President is so that these children's names are not given out, like what just happened. So part of it's to protect their privacy, part of it's also to protect children's names from being out there in the public. But your point is well taken. Okay. Next up, we have Mr. Michael Grath Moore. Mr. Moore? I hate to be the bearer of bad news, but you got about 5 minutes, and we've got a whole bunch of people that would like to speak as well. So if you could get to the most important piece of your description, I'm sure that members will have some questions that'll go on beyond 5 minutes. Okay?
Thank you, Mr. Chairman. I appear here today to attempt to convince you all to put me out of work.
Gladly like to.
Thank you. I'm a trial lawyer, and I provided the members of the committee with my statement previously, which addresses the specific issues that I have seen with children's services in litigating civil rights claims on behalf of families against children's services agencies and children's services staff over the last 30 years. I've encapsulated what I've learned in terms of the dysfunctional aspects of the Department of Child Safety. When I say I want this group to hopefully put me out of work, what I'm saying is I have provided targeted legislative proposals here, which doesn't cost the taxpayers much money and will pay for themselves over time, which I believe will end the need for lawyers like myself to take millions of dollars of taxpayer money on behalf of families. I talked about one case specifically in this statement, the case of Justin, Jackie, and Corin Stein. Corin's name is in the public record because of the civil rights case we won.
Okay.
That's just one example. Now, one thing I would like to address before I close, and that is something that's not in my statement, and that has to do with the Ombuds Office of DCS and whether or not DCS is policing itself properly. It isn't. I have the opportunity to take testimony under oath by representatives of DCS, and in the recent case, I took the testimony of a lady named Sarah Bruce, who happens to be a representative who operates in the Ombudsman's office as an advocate. In her testimony, Sarah Bruce admitted certain things. One is that she doesn't advocate for the parents. She doesn't advocate for the family. Her advocacy essentially is to go, when she hears a complaint and has a complaint assigned, go to the operative field staff, the investigator, the program supervisor, ask them what they did, get the explanation, pass it back to the parents who made the complaint, and that is a satisfactory resolution according to DCS. When the executive director was just here, she had a number of statistics. I would like the committee, if possible, to ask the representative or the executive director to provide this committee with the statistics of how many complaints are lodged and handled by the ombudsman every year, because I have sworn testimony from Ms. Bruce that there are between 10 and 12,000 complaints lodged with the ombudsman every year. And they're all resolved in the same way. I would like the committee to urge the executive director to provide this committee with the statistics which show those complaints which have been resolved to the satisfaction of the complainant, not to the satisfaction of the agency. So, given the short time I have, if anyone has questions, I'm happy to answer those. The statement is quite comprehensive, and I urge you all to read it. Thank you.
Mr. Moore, I've glanced at it, and have you thought about running for office? You said you want to get out of being a lawyer. I just want to give you an outlet for doing what you do so well.
I've been a trial lawyer for 45 years. I'm not going to stop being a trial lawyer.
Okay.
Your Honor, I was about to say.
I was just trying to add a little bit of humor to it. DCS is not the primary focus of this panel.
Mm-hmm.
What we were trying to do is get an idea of DCS's interaction and how that may affect the family court system.
Mm-hmm.
Certainly didn't have near enough time to have that conversation, but as you probably heard, I've asked the the Auditor General to add DCS, and it's my understanding that they're already on the list for their decennial audit. So if you don't mind, I would love to have some time after this hearing with you about things that you would recommend be looked at, especially with your intimate knowledge of their operations that came out of testimony. I think that's only natural. If you would make yourself available to my office, I'll make sure that we reach out to you, okay?
I certainly will, Senator Fitchman. One thing I would like to say based on what I've heard today, and that is the issue of these forensic experts talking about the family court. The same thing is true in dependency cases. The experts are on the payroll of DCS. These psychologists that do this are on contract, and they get a substantial portion of their income from doing these. And when they do these evaluations of parents, I've seen so many of them, inevitably there is some finding, no matter what, that there's a concern about the parent's fitness. So I think that's something very important for both the family court and dependency court.
I appreciate that feedback. Thank you. But,
Thank you.
Rest assured, I'll be reaching out to you to have some input into this. I'm always troubled by the throwing around of the term forensically informed.
Like forensic interview.
Yeah.
When the executive director invited you to understand that these investigators are trained in forensic interviews, I've deposed under oath dozens of investigators. None of them have expressed any knowledge of forensic interviewing techniques.
Yeah, so that's what I call croutons on word salad.
There you go.
Okay.
Mr. Chair.
Representative Kishel.
I told you he was awesome.
Yes, you did not disappoint.
So, Mr. Moore, since what you do is lawsuits with this, you defending folks' civil rights.
Yeah.
I'm assuming everyone in here understands that the taxpayers are on the hook when there's a lawsuit against DCS.
Yes.
What's the typical cost of that? What are we paying out of our pockets to defend DCS?
I can speak to a number of cases, mine as well. For example, in the case we just tried and won, and the state is going to pay $2.8 million. That is not just for the verdict and the attorney's fees that they have to pay myself and my co-counsel. The state hired outside counsel and paid outside counsel $1.3 million to lose the case. Now, these cases, if you review them, are settled. For example, the Briere case was settled about 5 years ago for $900,000. That was a removal case like all the cases I handle. The children out of the family for a few months, returned to the family, and the state paid $900,000. I settled a case on behalf of my clients Carl and Gretchen Daschke, in which the investigator took the two children for 3 days on a claimed exigency, which the federal district court, Judge Zips, found was unconstitutional, and the state paid $400,000. The problem here, though, is this. The fundamental problem is this here. DCS does not hold those people responsible who are found to have violated constitutional rights. In the two cases that I have where I have achieved victory in the court, not just a settlement, there has been no consequences for the investigator or the supervisor who were responsible for the violation of that family's rights and the horror that they put them through. That's one of the proposals that I have in my statement, a couple of proposals that will end the continuation of these folks who go on to violate others' rights.
Well, coming from a world that has IAD, that would be the Internal Affairs Division of a law enforcement organization, it's never a good day when you get called to that office. And I asked the director if there is an Internal Affairs office. I was rather surprised at the response. No.
Yes.
But we don't
Yes.
want our social workers to feel as though they're law enforcement officers.
Well, in fact, Senator, they are law enforcement officers.
That's
The investigators.
exactly the point.
Yes. I mean, and I say that in the statement, but the investigators go out to the home of people and they do everything that they can
Right.
to diffuse the idea that they're there to determine whether the parents have violated law. They do everything to avoid having to focus that I'm here to see, first, whether the child's in present danger, and second, if the child's in present danger, have you violated law, which takes you either before the dependency court, or I also pass that information on to law enforcement, and you might be indicted.
So you've helped make my point. When you're looking at a happenstance where there is endangerment or neglect, all right, in that moment where you formulate that in your mind
Mhm.
as a agent of the state, you have just entered law enforcement land in that instant. Because you're going to make a judgment call on what's my next step. So thank you very much for making the point. And
One thing I would like to say, Senator, on
Yes,
that
sir.
briefly. As you well know, a police officer has to go through AZ Post training, has to be certified. They receive tremendous education on constitutional rights of the people they encounter. Then when they go to their assignment, for example, the smallest police agency today, because I sue cops too and represent them sometimes, but the smallest police agency today has a policy manual which goes into all of those constitutional rights that they have to use when they encounter citizens. The executive director told you that these core training folks get training from the AG. Well, that might be true, but I have deposed numerous investigators and supervisors who can't remember their training. That's another reason why I propose a certain legislative response.
well, and post requires continuing ed every year. And I actually met with the director of post and have asked about, what about training on the state constitution? Do we have a reminder about certain things within it?
Mhm.
Do we have a reminder? And quite frankly, they don't. So that's another thing that we'll be looking at. It's when it comes to continuing education, it's kind of a free-form thing that each department gets to make a decision about. And as you well know, but maybe perhaps the folks in our audience don't, the Constitution does one of two things. It either prohibits police powers or it enables police powers. Nothing more, nothing less. That's what it's about. And by the way, the Constitution is a restraint on the government, not on the people. So,
Mr.
Ms. Cashel.
I have a really quick to the point, and then I want to let Rep. Fink go. So to your point about all of this, you have an agency who on their website, the DCS website, says that they are self-governing. And
that's a newsflash.
the last I checked was we and the governor and others have oversight over them. So you have an agency saying they're self-governing. That's not even true. And that's why we have an auditor coming in to check them out this fall.
Highly recommend it.
Mr. Chair?
Representative Fink.
I'm going to go back to the family court situation here.
Yes.
And I'd like to get your opinion on this, because what I have seen is that judges have basically taken parental rights away from, like, quote, the good parent without any due process. And so how would you hold them accountable for not following the law? Because they have not, I mean, I considered parental rights a Ninth Amendment right. The founders didn't want to include everything, so they put, because they didn't know if they might miss something, so they have the Ninth Amendment. I consider parental rights a Ninth Amendment right, and they have been denied that right through judges without, any documentation, due process, whatever. So just was wondering, what's your suggestions on that?
Thanks, Representative Fink. Of course, I work in the federal system. And in the federal system, a judge is absolutely immune from consequences outside of being reversed on appeal. We know that. Probably, I haven't looked at the state situation, but I expect it's the same in the state. I would look to legislation which specifically removes judicial immunity under certain circumstances. I haven't thought about that in great detail since this is the first time I've been considering it, but I believe there would be a constitutional way to do that, because obviously judicial immunity is a judge-created doctrine. It's not found in the Constitution. So it can be reversed.
Okay, thank
Well,
you.
and to that point, there is a question now that has arisen since Chevron. It is the legislature that makes law, not the judiciary. And as far as jurisprudence goes, I get that. That I forget the Latin term for it, but that which has already been decided, we're not going to destroy
Res
that.
judicata, yeah.
Thank you.
Yeah.
It's been a little while since I was
Yeah,
in
it's-
school. So
Me too.
I guess where I'm going with that is We have certain remedies at the state level for judges that are bad actors. And for those of you who are interested, contact my office. We're not going to waste our time with that because it's a long explanation. But the whole concept of court rules in the state, in the state sphere, rules carry essentially the weight of law. And thank you, Representative Culloden, who has shown a very bright light on rule-making authority in executive branch agencies. We are now questioning rule-making authority, and I know that the judges are watching this, so be forewarned. We are looking at rule-making authority within the court, and if that carries the weight of law, then it is a separation of powers issue that needs to come before the legislature to approve such a rule. To your point, it's judge-made law. So, I appreciate your testimony. Members, do we have any more questions? No. We'll have your contact information, and I would be delighted if you would join us in the working group that's going to be writing the legislation here at the state level. I understand that you're operating in this federal sphere, but I think that you're well informed in some of the challenges that we're going to be facing. So thank you so much for your time.
Whatever time I have that I have beyond devoting to my clients to get them justice, I'm most willing to work with you all. Thank you so much.
Oh, and I would, one more thing, it's been, this is a thought that has kind of percolated up here. The outcome of the professional always seems to be captive to the person that's paying for them. Would you agree to that?
Could you repeat that one more time?
The work product of a professional always seems to be tethered to the individual or where they're getting paid from. So, for example, a psychologist. If he's being paid by one party, it would seem that he'll be tethered to that party's interest.
I think what we have to do, of course, in my area, I'm in litigation, so I'm on the opposite side, and my client hopefully can pay me, probably can't, but my position is to further that client. However, I agree with you. It's not necessarily suspicious that an expert who is called upon by the court or is called upon by the agency to conduct some kind of evaluation isn't necessarily biased. However, you must be extremely careful as to that expert's amount of income they get from that, how many times they are involved, and how often they find, for example, that the parent has a mental illness or an emotional illness, or the child has an emotional illness that requires separation from the parent. Those are data that we don't have.
Okay. Thank you very much, sir. I appreciate your testimony.
Thank you.
All right. Representative Keschel, who's next?
So we're going to cruise 3-minute testimonies, and I just want to encourage you all, if you don't get a chance to speak, we are going to have a lot of legislation starting in January that we're going to need your help coming to the committees and testifying on. So we want to have your voices heard at some point. Next one is Brad Brock.
Good morning, everybody.
If you would, please get as close to the microphone as you can and give your name for the record,
Is that
who
better?
you represent, and you got 3 minutes.
All right, thank you. Good morning, Senator Finchman, Representative Keschel, distinguished committee matters, members. My name is Brad Brock, clearly very nervous. I will try to cruise through this as quickly as possible. My custody battle started in 2017. At that time, for context, I've spent roughly $200,000. I now represent myself. I have gotten comprehensive family evaluations. DCS has been involved since 2017. So I think for today's purposes, that's in the short amount of time, that's where I will focus my testimony. The first time my son was exposed to marijuana was in 2017. DCS noted that in the report. I asked everybody that was involved to get my son tested. They would not. In March of 2020, my son tested 4,625 parts per gram for marijuana. I have proven that he was exposed to it. I've proven that he has ingested it. Mom at that time was substantiated by DCS for child neglect and child abuse. Through through, I guess, unsavory actors, I was forced to sign an agreement to get it out of court, at which time mother had said she wanted to go back to using illegal substances. I begged and pleaded for a safety plan. With the judges, with the best interest attorney, I was told no. That was June of 2022. September of 2022, he tested positive again for marijuana. The first time was the day before his 3rd birthday. The second time is when he was 5. Mom tested positive 4 hours before picking him up, and I called DCS, and nothing was done. The DCS case manager brought the Scottsdale Police Department out to my house, which is fine. I've been cleared by everybody, and every statement I am making today, I have court documents, audio recordings. I literally have everything to prove, to substantiate my testimony. I have given this to the courts, and they have turned a blind eye to it. I have, so they came out, brought the police to my house, and my lovely son invited them in for breakfast. They, of course, did not come in until I came to the door. At that time, I was told that they knew who did this, and they were going to take the police there. It took me 2 years to get that DCS report. Come to find out, not only did they not take the police there, they gave Mom 2 days to take care of her house before they even showed up. There is in that report, there is a litany of factually incorrect statements which I can prove.
Okay.
So I guess I don't.
Time's up.
Yeah, that's time's up. So
So if
It's
you
much
have-
deeper than that,
if-
too.
If you have something documentation-wise, please send that to my office. We'll make that part of the annex of the report.
okay,
The only question I have for you is who's the judge?
I am not going to say that because I'm actively. I will email it to you.
Okay, so tell me.
Yes, there's been 5 judges. The first 2 were great, Judge Bergen and Judge Kramer. The last 3, you know of one. I know that for sure. I've done a ton of research on this,
Okay.
where I was denied
So-
due process as well. To the best of my ability, I'm not an attorney, but
So in a word or two,
yes.
why do you have trepidation about naming the judge? And it's not a trick question. I want to know what's on your mind, what's forefront of your mind about naming the judge that you are currently in front of.
Retaliation.
Thank you so much.
You're
All
very
right.
welcome.
Next. Thank you, Brock. I appreciate your testimony. And by the way, would you please see to it that this lady over here in the maroon jacket get your name, contact information?
Yeah, I have it
All right,
in here.
thank you.
All right, next one, Brian Gable.
By the way, for those of you that are testifying, I don't want to hear your spouse's name. I don't want to hear your kids' names. But if you've got an attorney, a psychologist, or a judge, I'd be happy to hear their names, unless, of course, you're afraid of being retaliated against. Sir, if you would, please give your name, who you represent, and you got 3 minutes.
Good morning. My name is Brian Gable.
Get as close to the mic as you can, Brian.
My name is Brian Gable.
That's good.
Good morning. I'm here today. I have an attorney, Oz Morgan, and my response in being here today is because I'm on the other end of the spectrum of Mr. Moore. I've been divorced for 2 years, had a 50-50 plan. The divorce judge that I had saw through my ex's smoke and screen show. 2 years after the divorce, I've come up, I've done what's right. She's always requested money, forced money, fabricated lies. I just don't play into it. September of 23, upon picking my son up from my house, she had me served for change of modification as I build power lines and I worked out of state. Went to court, did not have my 5-day evidentiary hearing. The judge at that point acknowledged it. We got a temporary order at that point. 2 weeks later, my son had gone out back at 4 years old as I had let my puppies out and got knocked over. I informed the mother of the incident. What I didn't know is the night that she had me initially served, she called DCS, filed a police report. Same with this time. She went down to Phoenix Children's and claimed that I was an abuser. I had abused my child. All while there, DCS asked my son, the nurses, "How'd you get the injuries, buddy?" He goes, "Oh, my dad's. The dogs knocked me over." Yet DCS has substantiated the claim against me. The judge has denied everything that my attorney has brought to her attention. There's been allegations of drug and alcohol abuse, which I've produced on my own accord, and 18 years of national, federal urinalysis test because I am a CDL holder, and the judge still refuses to allow me to see my son other than supervised visitation. She made a ruling after 4 visitations that I continue, all while my son is in front of the supervisor saying that my mom told me I can't come to your house, making my son call me by my first name instead of dad. All because she's, my ex is involved with a Buckeye police officer, and he's buddies. And that detective that came with DCS, who, by the way, none have contacted me 2 weeks prior to any of this information that's been brought against me, writes a letter to the judge before even contacting me, letting me or informing me that I have a detective investigating me, stating and making statements that he's found it that I'm very uncredible and in a dangerous position to even have my son around unsupervised.
Time.
Your time's up, sir. Thank you very much for your testimony. And the judge's name, if you feel like giving it up?
Julian Francis.
Okay. All right. And you have legal representation?
Yes.
Okay.
And I just want to tell you, Brian, I just got a message on my phone saying what an amazing father you are from someone who knows you in this room. And having met you last week, I agree, and just keep up the fight.
Thank you.
All right. Thank you, sir. All right, next up.
Adrian Polkerbeck. Is he still here, or did he have to leave? Oh, you're hiding back there.
Hello, everyone. My name is Dr. Adrian Polkerbeck. Oh, by the way, to all the senators and representatives, I'd like to say hi to you. And Representative Fink, I appreciate you asking about parental rights. That's really good.
You got 3 minutes, sir.
Okay. I've heard some other people speak, but let's not assume anything here. We need to think about what's in the best interest of the children. I wish we could speak in more neutral terms instead of assuming that all men and all fathers are abusers. Abuse happens from mothers and fathers. There are many parents that have their custody time limited or taken away that should not have from false allegations. I had 2 DCS false allegations of neglect. The DCS came out to my house, they investigated, they found no neglect. They even wrote in their write-up, children appear to be coached. Now, there's a lot of harm that can happen from false allegations, especially the children, which we're not thinking about. Abuse can happen from both parents. Now, I don't have very much time, but I want to talk about how studies are showing how unequal parenting time has a direct relevance on the increase of suicide rates of teenagers. This is all according when a judge removes or limits half the supporting structure of a child, there's a 63% increase in teenagers who die by suicide. There's a 71% chance of high school dropouts when there's an unequal parenting time. There's 75% of children in chemical abuse treatment centers when a judge removes or limits half the support structure of a child. There's gun violence. Children are 3 times more likely to carry firearms when a judge removes or limits the support structure of a child. And this is all information that I can give any of you these are all reported from the Center of Disease Control, American Journal of Osteopsychiatry, everything, the Journal of Family Psychology. These are not statistics I'm making up here. School shootings. A recent study found that 87% of children involved in school shootings have a history of one majority-time parent. Let's see. Drug dealing. Teens are 3 times more likely to engage in drug trafficking when a judge removes or limits half the support structure of a child. Behavioral disorders. 85% of children exhibit behavioral disorders for the same issue. Depression. These children are higher risk of experiencing depression, anxiety disorders, increased anxiety among children without equal parenting time. Low self-esteem. There's a greater likelihood of low self-esteem to these children when a judge removes or limits half the supporting structure of a child.
Go ahead and just finish up really quickly, Adrian, please.
Oh, certainly. There's other issues I could go over, a lot of statistics, but what we need to do is what's in the best interest of the children. Other states are passing laws or have already passed laws to address this injustice of the family court system. It's time Arizona does the same. Thank you.
Thank you so much.
Thank you, sir.
Okay.
Members, any questions for this gentleman?
So Mr. Chair, I just have a statement. So I've been working with Adrian, well, myself and Representative Fink. I know that there are some concerns about the 50-50 laws as far as, father's rights being the trumping other things, but there are dads that are also being overlooked in the court system. So we're working together with a representative from Texas, actually, on how to make sure that we can kind of do all of what we need to get done here. So I really appreciate all the hard work you're doing.
Oh, you too. I appreciate it. Thanks.
Thank you, sir. Next.
Okay, so next we have Mary Betzold. Sorry if I butchered your last name.
Please give your name for the record and who you
Mary.
represent. And just
Mary.
get as close to the microphone as you can.
Is that better?
Thank you.
Okay. I'm Mary Betzold, and I just represent myself, I guess, and I had experience with 5 years of family court. My judge was Judge Adele Ponce, and I was taken to court by, obviously, the father of my 10-year-old at the time, and she's 18 now. But I was in there for 5 years. And what had happened is all the allegations were dismissed, or I proved wrong all the allegations, the basic ones: drug abuse, neglect, physical abuse, verbal abuse, and me as far as being mentally unstable was my accusations. We went through 5 years of that, and long story short, what had happened was I had passed my hair follicle the day of court. I fought for the other party to have a drug test. Was not given until 2 years later after mediation, and we had agreed on everything, joint everything in mediation, 6 hours at $250 an hour with a retired judge. And what had happened is it came to the last thing that I had to prove that was not, till I get my parenting time back, was an intervention, family intervention, which I was told it would be evaluation of the entire family, which I agreed. Which I was like, okay, great, let's do that. And at that time, if I'm unfit, then so be it. At least everybody's being evaluated. The scope came out, mom and daughter have issues, and nothing was done. The father was not involved in that intervention or anything about it. I worked for a year with a family interventionist, Dr. Corson, which was awesome. I did everything and some. What she was asked of me, excelled in every area, and worked up. And the agreement was, if and when it's appropriate to get my time back. So I did that.
Excuse me, who defined if and when?
During the mediation, we agreed that his lawyer said if and when my parenting time is appropriate based on my daughters and our relationship, because there was obviously a disconnect there because of everything. And so
this was done through the mediator.
This was the agreement that we left at mediation with.
Okay.
Okay. So
I just wanted to understand.
Yes. Yeah.
Who defined that?
Yeah, that would be his lawyer, the dad's lawyer, and so he drew up the parenting plan, which I did not sign. And so I agreed to do the interventionist, and I did it for about a year. I worked up, based on our relationship, worked up to 1 day shy of 50-50 time, which I should never have done that, but I did. And so it came down to reappoint the Dr. Corson. And we had about a month left of therapy left between my daughter and I to get that extra day. So we would have been at 50-50 time. And then the parenting plan would have been established and my parenting time would be on a minute entry. However, when we went, I was able to obtain video footage of the father snorting cocaine. I filed that, and we called DCS, and they did not open a case. We requested a status conference. We did not get that. Then all of a sudden, they lodged the parenting plan that I refused to sign because there was things that we didn't agree with in mediation. And I said, well, let's just take it to trial. And they lodged it. And it was all at the same time as when I filed my emergency order, when I found the video of him snorting cocaine. I was denied the emergency order. He was issued a hair follicle, which he failed for benzoids and cocaine. I filed another emergency order. At the same time, it was like simultaneously, I watched that ECR, and they did not, when you have the emergency judge, which I'm sure you know, does not rule on it if there's a parenting plan signed. So hence why they decided to lodge the parenting plan, as I was not signing it for unreasonable cause, is what they said. However, all at the same time came out when the emergency judge had the failed hair follicle. She lodged and signed that parenting plan.
Okay.
So,
Yeah.
get to a stopping point, please,
Yeah.
and get to where you are at now.
So that it's right there. So then at that point, I was denied the emergency order because the parenting plan was signed. Then the judge called a status conference right after that because the other party wanted to not reappoint my family interventionist. And so we went to court, and she awarded to not reappoint the family interventionist, even though we had 1 month of treatment, one more day, and that's how it was left. I still, to this day, and my daughter's 18, do not have any parenting time on record for anything. And I was able to, I gave up, and I worked with my daughter and we are good now to a certain extent. We're building that back up still today, this long ago, so that's where it was left.
Okay, so your child is no longer a minor. They've aged out of the system.
Right. Mm-hmm.
How old?
She was 10.
She was 10?
I missed
so
everything.
You lived through
Mhm.
this for 8 years.
Yes, and I have 2 other kids as well that have lost the time with their older sister.
Right, okay. Who's the judge?
Sorry. Adele Ponce.
Okay.
And also, I just wanted to say one other thing. The court-appointed advisor did not come to my home. She falsified my conditions that she said I had because my fiance had 7 years ago shot himself in front of me, and that's where it all came from. And so I had PTSD. I told her that, and ADHD, but she added that I was bipolar and that I was off my meds, and falsified my therapist notes that I provided and disregarded evidence I submitted to her, did not come to my home, and recommended that I have supervised parenting time, and he took a parenting class.
Okay.
So,
All right. So you've got somebody who falsified a document, presented it to the court, and as such, your civil rights were abrogated.
mhm.
Understood.
Mr. Chair,
Yeah.
just to follow up, would you mind naming that person who falsified documents?
Yes, Janice Fuchs.
Okay,
I'm sorry, who?
Janice Fuchs.
good to know.
She was with ADC Counseling, I believe. It's a third-party person, yeah.
Was that individual, did you have to pay them for the work they did?
I believe there was a fee.
No,
Yeah.
no, that's not what I asked. Did you have to pay for any of this, having to do with your evaluations?
No, because the father agreed to pay for it. He was paying $250 a session for their interventionist, and then it was $300 an hour, I believe, for the mediation, which was 6 hours.
So it begs the question, which I asked Mr. Moore. Does the work product appear to be tethered to who's paying for it?
Yes, yes, and I paid for my lawyer, which which I found out was in cahoots with the other lawyer. I got him from Modest Means, which was a discounted company or organization. So I paid for that, $75 an hour. And
Right.
he ended up withdrawing the day before my last status conference, and I asked the judge, do you normally sign off on a parenting plan for a parent who failed a hair follicle for cocaine and benzoids? And she said, there's no motions before the courts. And that's how that hearing was left.
Okay.
Okay,
Thank you, ma'am.
thank you.
Okay, next speaker,
Next up.
Mr. Chair, is Autumn Manelik, or Manelik.
Okay, Autumn, you got 3 minutes. If you would, please give your name and who you represent if it's not yourself. And get on it.
Thank you, sir. Thank you, committee
Get as
members.
close to the microphone as you can, please.
Thank you so much for having us and having us. Thank you for this committee. So I am a California Family Court refugee. I have come to Arizona specifically because of this committee, and I have bought property in the state of Arizona and rented a house for my children specifically because of the work of this committee. So what you're doing is important, and it's about to be national. So my name is Autumn Manelik. I'm a survivor of both domestic violence and family court abuse. I'm also a podcaster and the host of The Trebuchet, a platform where I expose the truth about domestic violence in the military and help other survivors of sexual assault and domestic abuse within the armed forces report their assaults and hold their perpetrators and the institutions that protect them accountable. My story begins in the military system, where crimes are hidden and mishandled. When a victim reports a crime, local law enforcement is often never notified. Or if a victim does report to civilian authorities, the case is deferred back to the military chain of command, even if the crime occurred off base, under the guise that it happened on base dealing with servicemen. This means survivors like me are forced back into a chain of command system where their abuser, often of much higher rank, controls not only the military investigation, but also exerts influence on the civilian courts. It's a system of double victimization, first by the abuser, then by the institutions meant to protect us. When I entered family court in Monterey, California, I expected fairness. Instead, I found a circus. The judge is the ringmaster, orchestrating the performance, but blind to the suffering beneath the spectacle. The lawyers are the barkers, shouting, "Step right up," luring us into a system that devours our finances and dignity. I personally spent over $150,000 on fraudulent attorneys before I had no choice but to represent myself pro se, making significantly more progress than the lawyers I had paid to assist my children and I. The guardian ad litems are trapeze artists, making us cling desperately to their rules, fearful our children might slip from our grasp at any minute. The paid visitation supervisors are the fire ring holders, forcing us to leap again and again through hoops that are unlicensed, unregulated, and psychologically harmful. If we don't perform perfectly, we get burned, and we pay for the privilege of being scorched. And the psychological evaluators, many of whom we are finding are not even licensed, including the evaluator in Colorado, who a brave father recently exposed and is now serving jail time, which means that there are pathways to hold these corrupt individuals accountable. The psychological evaluators are the lions, either defenders or destroyers. They pathologize predominantly mothers because fathers habitually attempt to paint them as crazy. This tactic is especially common after long marriages where men, military and civilian alike, learn that if they can get their wife charged with domestic violence, they can escape spousal support obligations. This also goes the other way, and I am not blind to that. It is a systemic tactic, and judges...
Go ahead and find a place
Got it,
to
okay.
yeah, stop.
It's a systemic... Okay, the tragedy is that the circus runs on the backs of families like mine, parents who pay for their own destruction while the children's well-being is gambled away. That is why I built the trebuchet. Like the medieval device, it is designed to hurl truths over the walls of silence and into the public square, clearing the way for real warriors of justice like this committee to act. I intend to use my platform to make sure no family feels isolated in this battle. Survivors across the country are rising, telling our stories and documenting corruption. Gag orders will not stop us. Ironically, in my own case, the court itself acknowledged my podcasting, even ordering me to return to work as a podcaster. If they sought to silence me, they failed. Instead, they gave me my voice back. And I'm here today to tell you, the family court is not a neutral arbiter of justice. It has become a circus, a business, and in too many cases, a weapon used by abusers to silence survivors. But it can be reformed, paid players can be removed, and licensing, oversight, transparency, and accountability can be legislated. Survivors like me will keep launching truths until this happens. Thank you so much for your time.
Okay. For the record, I want it known that this committee is not an economic development committee trying to get people to move to Arizona.
Well, you got me.
But I really do appreciate your testimony, ma'am. I thought I saw her in the room. Is Master Sergeant Ross here?
She has to go pick up her son. She'll be back.
Okay. Please do not leave. I need to connect you with Master Sergeant Ross.
Thank you.
And
So if she's coming back, when she usually executes on everything she says she's going to do, I want to connect the two of you. Okay.
And really quickly, I think I'm your representative.
Yeah.
So let's make sure we connect too.
Okay. Thank you so much.
Thank you so much for your
Thank
testimony.
you.
Members, any questions for this lady? No?
Okay.
All right.
No
Thank you.
questions? No.
By the way, ma'am, great job.
Thank you, sir.
Thank you.
Okay.
Okay. Who's next on the list?
Next up, Dean Janosko.
All right, sir, you got 3 minutes. Get as close to the mic as you can. Give your name for the record, please.
Okay. My name is Dean Janosko. Thank you, Representative Ketchel, for bringing these horrendous violations of the rights of families to light. I am one of your constituents and so appreciate your work. I'm going to speak about something I believe no one knows. There are extreme problems with DCS blocking safe, fit grandparents who have deep bonds with their grandchildren. When DCS determines to seize a child, my daughter Giovanna H., who was attacked by this department, had an underlying medical issue that was never considered or addressed by anyone in this system but for her family and her ADA advocate. Her condition and its source were covered up and ignored, and as a result, her life and health have been destroyed. I am sure other Arizona parents have suffered the same as my poor daughter and her entire family. As the cash incentives for DCS to those attached to the system benefit from the schemes and their patterns of practice. As DCS seized my grandson, I rushed to the scene with his car seat and diaper bag and the foods he liked to take my grandson home with me. And DCS passed me over as if I didn't even exist. In 2021, when this happened, we had a law called Family First of 2018. And Arizona has done a lousy job initiating it. It all began the day my grandson was born. My daughter was given oxycodone. After a C-section and experienced an immediate adverse reaction to it, I asked her doctors to stop giving it to her. Instead, she was sent home with a huge prescription of oxycodone. The side effects were horrendous. She could not sleep for 2 weeks, and her condition became an emergency. A weekend, she began to self-withdraw, but was forced to seek help at Sonora Mental Health in Tucson. She checked herself in to therapeutically withdraw from oxycodone, but she was denied a drug recovery coach. Instead of diagnosing her with opioid-induced psychosis, they diagnosed her with postpartum depression and psychosis and began drugging her with a typical antipsychotics against her will. They held her down in bed, smothered her with a pillow, and when the pillow was removed from her face, she opened her mouth to breathe, and Sonora's staff shoved pills down her throat and plunged a needle in her arm and called a B-52. Benadryl, a sedative antihistamine, is included for sedation to counteract movements disorder caused by Haldol, Ativan, and benzo. Recent studies are showing that the use of B-52s may lead to more side effects and longer hospital stays. My daughter was unconscious for 3 days, and although her husband, the baby, and I went to Sonora to see her, they refused us access.
Okay, sir.
We
I need
worked
to have
sick.
you wrap it up.
Okay, the Sonora fabricated outrageous lies against Giovanna in order to trap her into COT court-ordered treatment for years of drugging. As she prayed help from God, they tagged her with hyper-religiosity, and DCS said that it was a mental disorder with set with demonic features. So Sonora staff reported that my daughter, with a deep cesarean wound, had nurses said she tried to break out through a window and jump over a
Okay, sir.
thing. So
Sir.
a station. Yes.
We need to put a bow on this, okay?
Okay. So,
I guess what you're trying to tell us is you're not very happy with DCS's involvement with your case.
no, and they took my 4-year-old grandson and annihilated me,
Okay.
besmirched, me,
Did you ever
assassinated my
have-
character.
Did you ever have an actual meeting with the DCS field agent? I mean, did you actually talk to an individual face-to-face? Because what I'm getting, there's this recurring theme with DCS
Yes.
that there's either no contact or there's a contact over the phone.
They didn't let me go to the foster care review board. I went to every single meeting.
Wait a minute, they didn't let you go. It's a public meeting.
They didn't inform me. They didn't let me go.
Well,
They-
okay, no, it's not that they didn't. If you're telling me that they prevented you from attending, that's different
Yes.
from not telling you about it.
Yes, yes,
So they stood in the way of you going to one of these hearings.
yes. And they said I couldn't appeal my case. They, when they terminated my daughter's rights, they terminated my rights right after that. They said it was already in appeals court, and I said, how could it be? I haven't even gone to court yet. Then I asked them, where are my records? We can't tell you. Well, where's the appeals court? We can't tell you that.
Okay. So this
So-
is going to require much more follow-up.
So Michael, the
Okay, sir,
proceeding
sir,
judge.
Sir,
Yes, sir.
this is going to require a whole lot more follow-up than we have time for today.
Yes.
So Representative Kishel has your
Okay.
name and your contact information. We are going to put this in the category of demands further attention. So somebody will be reaching out to you, so you've got an opportunity to document this, and we will go toe-to-toe with DCS over it. Okay?
Thank you
All right.
very much.
Thank you
God
very
bless
much.
you.
Okay.
Okay, Mr. Chair, next up is Michael Bertrand.
Are you in the room, Michael?
Yeah, he's coming.
Oh, must be the blue hat coming forward. All right. All right, ladies and gentlemen, we have 20 minutes left for this hearing. We have a hard stop at 12 o'clock. So, and it looks like we've got about 50 requests to speak. We will probably reach out to you so that you can give us written testimony that we will include in the record. But we, with the constraints of time, we've already been at this almost 3 hours. So, sir, you got 3 minutes, if you would. I know you flew in.
Yes, sir.
I'll try and be lenient with you, but let's be respectful. We got to get 4 or 5 people to speak the same
Yes, sir.
in this
I
time.
am about to disclose a national security
Okay,
violation.
so first of all, I need to have you give your name and get as close
I
to
am
the
Michael
microphone as you
Bertrand.
can, because I can't hear you.
I am Michael Bertrand, and I am going to disclose a national security violation in my testimony.
I'm
This
sorry.
has been going on.
Stop. You are going to disclose a national security violation with your testimony
Yes, sir.
of yourself or someone else.
Involving me in this issue. And I will do it gingerly because I believe it needs to be delved into.
I would prefer that you not do that on the record until we know what that is and whether it is protected under federal whistleblower law. All right?
I have had 4 assassination attempts on my life. I have 2 feet of scar. I am missing one of my internal organs and 3
Okay.
others permanently damaged.
Does this have to do with child custody? and-
Absolutely.
I'm sorry?
Absolutely.
Okay. 3 minutes. Let's steer away from the national security stuff and let's talk about your interaction with the court and family court orders.
This is 16 years now. And I have been called the leading historian regarding the closing of Child Protective Services by a top 15 attorney of 25 years at the time. With this,
I need to have you get closer to the microphone, sir. I can't hear
I'm
what
going
you're
to I'm going to say that as far as disclosure of evidence, here's a drop in the bucket that you can look at. It's if you Google Saving Grace Advocates leg break threat, it just gives a small insight as to what's been going on. Because there is so much evidence that's been accumulated, the Superior Court has referred to it as voluminous, which as of right now, I have submitted more hard evidence than the court has ever seen regarding these issues. You're talking about symptoms that are occurring. I went and tracked down the sources of what's going on. And I am still 16 years later at a tit for tat with a terrorist organization that was introduced into this. By far the most egregious facts of this is the suffrage of the children that were involved. Egregious abuse of the children. That's why I am still here. Otherwise I would have walked away from this long ago. The cost at this point is over $1 million.
I'm sorry, personal
The-
cost to you
oh, yes.
is over $1 million?
Correct.
Okay.
And so to try and put the 16 years of what's been happening into 3 minutes, I'm gonna do my best. An official sworn report was made to law enforcement in the court. These statements were admitted, found as perjury, recanted, after the fact. And this is where the significant costs started escalating, and the physical injury and the financial injury, and the well-documented abuse of the children. A third-party gang officially categorized as a terrorist organization on court record terrorizing court witnesses. The record shows the terrorist involved as a third party was operating under protection of written legal instrument of the Arizona Superior Court. I have a voluminous amount of facts regarding these circumstances, approximately 1,400 pages in a condensed version. Literally, we could probably bring maybe 7,000 pages. However, once you see what's going on, it can be articulated within 1,400 pages. So within that 3 minutes of testimony, I know it's always good to have a solution, which outside of a grand jury, I'm not sure exactly what it is. However, knowing what I know and the time I have in this, and I know who certain actors are, and a fourth party involved, I would gladly volunteer for the opportunity to track down with the skills that I do have, my law enforcement training, to participate and answer directly to you with articulated legal approach in how to surgically remove the tumor that is on the heart of this community.
If you could wrap it up, please.
I don't know what more could be said.
Okay. Members, any questions? Okay. Obviously, we don't have the time to give you justice to 1,400 pages of material. However, if we've got your contact information.
I believe Elena has my contact information.
Then we'll have Elena reach out to you and get that from. Okay?
Okay. And I believe that there's a responsibility with knowing this evidence. It's that this type of organization is operating within your state jurisdiction.
Okay.
That there's a responsibility to take action on
We'll
that.
follow up with you. Okay? All right. Thank you very much. Next.
Lori Ford.
If you would please give your name, who you're representing,
Sure.
and get as close to the microphone as you can, because this gentleman we just had, I could barely hear him. So
Right.
speak
I
up.
think I'm good. Tell me if I am.
All right, you're good.
Okay,
3
good.
minutes. You're on the clock.
Thank you. Co-Chair Keschel and Fincham and the rest of the committee, thank you so much for having people be heard. My name is Lori Ford, and I am with the AZ DCS Oversight Group. We are a grassroots organization. Pretty disappointing, but we have come to expect it, that as soon as the public starts to speak, DCS dips out. Not that I want to tell you how to, run your meetings, but possibly it would be more beneficial if you had the public speak, then you can ask DCS questions.
Well, I
So
think you
they
might
can
have
be
missed,
in after.
to that point, Ms. Ford, you might have missed my introduction of the DCS folks. This is not a hearing about DCS.
I understand.
That will come in due time.
I understand.
So
Just wanted to put
please
that out there.
proceed.
I don't want to tell you how to run your meetings.
Then don't.
So there's a lot of experiences with DCS and family court. As a court watcher, there's been many, many hearings where DCS wants parents separated. And this means cohesive parents as well. So DCS follows them through the family court system to make sure that they have filed their legal separation papers. Then this is brought up hearing after hearing. The next time, it's divorce. They want cohesive parents to file divorce. And by God, DCS is going to make sure that they hold those kids out as a carrot to make sure that happens. I've seen it time and time again. Representative Fink, you said that you've been involved with family courts. I hope you're attending the family court judges meetings. I attended every one of them for, I don't know, 4 years probably. And back in 2021, Family Court Presiding Judge Bruce Cohen was meeting with DCS, and he guaranteed that all DCS records would be brought into family court when the family court judge ordered them. He said he met with DCS on several occasions, and finally, it was agreed upon. DCS signed a document that they would have all records into family court within 90 days after they were ordered to do that. I spoke at every single one of those meetings, and all of a sudden, that topic went moot. So I brought it up again. That's when Judge Bruce Cohen said, you know, met with DCS. They don't have the capabilities of doing that.
Okay, so Lori, wrap it up, but I actually have a question for you. Was that something that they made in policy, like in their policy?
No.
What?
It was, I want to call it a promise of, something promise of something.
Okay, so we need to put something into
yes,
law.
and I went through, I am like active note taker, right?
Well, we do have a staffer who attends those meetings.
Oh, who is that?
Lady in the maroon jacket. She may attend them remotely, but she is.
Sure.
Okay, so she is
So,
keeping a watchful eye.
because now they've rebranded themselves.
Well, and quite frankly, they, there's a funny thing about public meetings. Whenever you have a public meeting,
Mhm.
that's a great source for future legislation. So
Well,
I'm not going to reveal what it is we have on our agenda, but I'm pretty sure that that committee is not going to like it. Okay?
Good.
Representative Fink,
Yeah,
you have
to
a
the
question.
point, yeah, with Representative Keschel, in regards to, you know, between the judiciary, the family courts and DCS, you said they made an agreement. Is that documented? Is that something that
It
we
should
can
be
see?
documented. It was made with, Shalom, I can't remember what her last name was.
Was this for a specific, I'm sorry, to that point, is this for a specific case, or is this for general standard operating procedure for the court?
Any
Okay.
DCS case, whether it goes back 10, 20 years.
Okay.
If there was a DCS case and these parents are getting divorced, or one has remarried and they're going to divorce the second guy,
Okay.
they want all those DCS records in, which, by the way, the DCS guardian system, Judge Bruce Cohen said, doesn't have the capabilities. Hell, we've known that for years, and we have been in front of legislators, we have been in front of DCS committees complaining about that. It's still not done. So we have non-disclosure violation of rights,
Okay.
due
So
process
we-
for decades.
We will, at some point, take up the DCS thing, but that is somewhat outside of the scope of what this committee is for.
Right?
I'll be happy to make sure that you are informed of when that is. There is going to be, I believe, a House hearing that's going to deal with this. At some point during this coming legislative session, I can virtually guarantee that there will be something in front of the Judiciary Committee in the Senate.
Okay.
That would be probably a more appropriate time to have you speak to this, because we've still got a bunch of people and we've got 7 minutes
Yes.
left.
Well, there
Okay?
is a direct pipeline from
No, I get
DCS
it.
court to family court.
I
So,
get it. Thank you very much.
thank you.
All right.
All right.
We got time for 2 more people. Be respectful of each other. And the next one up is
Nicole Skinner.
Nicole. Nicole Skinner. Going once, going twice. Oh, there you are. All right. If you would, Nicole, please give your name for the record, who you're representing, if it's not yourself. And there you go. Get as close to that microphone as you can so we can get you on the record. No, close to the microphone. Like
Is this
this
good?
close.
like this.
Yeah, and speak up.
Hi, my name is Nicole Skinner, and I flew all the way across the country from Ohio to be here today. I'm going to go ahead and skip all the pleasantries.
Please do.
So, in my case, that's been going on for nearly a decade in the Lorain County Common Pleas Court Domestic Relations Division. I'm going up against a police officer who has a personal relationship with our judge, who is Judge Sherry Glass. He also has a professional and personal relationship with her spouse. I have phone records that were subpoenaed showing ex parte communications between the two of them. I have spent over $1.8 million in the course of this almost decade battle. I am currently waiting on a decision from the 9th District Court of Appeals for a DVCPO that I had to appeal when the stepmother burned my son, leaving a second-degree burn on him. Apparently, that's not child abuse in the court's eyes. Every level has refused to investigate. Police officers, CPS, the court, federal, I've gone everywhere. I can provide an entire list for you, along with every single player that has been in this case. Falsified documents, judgment entries from the judge that are wildly different than what the transcribed testimony from actual proceedings show, claiming that there was zero evidence when it actually was introduced on the record. I've had stalking and menacing by not only the father, but also his neighbors, his wife, her family, additional things like that. My brake line and power steering line on my car were cut right before a hearing that I had to go to. And most recently, in November of 2022, my house was set on fire while my son and I slept. They refused to investigate.
I'm sorry, when you say they, can you?
Law enforcement.
Law enforcement.
As
And
well as.
What community do you live in?
I live in Vermilion, Ohio, Lorain County.
Okay.
As well as the actual fire chief.
Okay. And what's the population size of your little community?
I am not sure, but it's pretty small.
10,000, 40,000, 100,000?
My case is in Lorain County. I live in a different city than the actual county, so I had to move. I've moved 3 times just to get away from somebody and get my kid in school.
Yeah, I'm just trying to understand. Is it a big community, little community?
No, not really. It's small.
It's small. Okay. All right. Your time is up, ma'am, and I appreciate the fact that you've flown here so long to tell your story. There are some resources in this room that I'd like to get you connected with.
Absolutely.
Okay. Your story is, like so many others, tragic. And I would like to get you in touch with a friendly legislator in Ohio.
Hopefully it's one I haven't talked to that denied me.
Well, that's okay. They work for you.
Okay.
Yeah.
I also do have a copy of the Ohio amendment that we are trying to pass to get rid of, I can't even think of the word right now. I'm sorry.
That's all right. It's stressful.
Yeah.
If you would, please hand that off to this lady over here to my right.
Qualified immunity.
Ah.
Has
okay.
all of our stuff. It has been approved for use in Arizona.
Great. Please hand that off to her. Thank you very much.
Thank you.
And if you would, hang around for a little while after we gavel out, and I'll get you connected with some resources. Okay, we got time for one more.
Okay. Zadie Rule.
You got 3 minutes, ma'am. I hate to be hard on that, but that's going to get us over the 12 o'clock hour. So if you would please give your name, who you represent, and get as close to the microphone as you can.
Okay. My name is Zadie Roll. And
Speak up, ma'am.
Can you hear
Put
me?
your loud voice on.
My name is Zadie Roll, and I am a constitutional rights consultant and advocate. I'm here from Idaho. I travel all over the country. I come to council meetings all over the country. I go to courts all over the country, federal and state. I must commend you today. I am very impressed with the work that you're doing here. And I am not seeing it in a lot of other places. Anyway, I do have something that I would like to mention. And I prepared, hopefully, something that's less than 3 minutes. Yesterday in Nevada, the magistrate refused to return the Burr, B-U-H-R, children to their parents, and instead stated they will expedite transfer to Arizona before releasing them. We have already filed a $50 billion with a B dollar instrument to, quote, buy back the children from this unlawful trafficking scheme, and Nevada has cashed it. If Arizona unlawfully accepts these children as a transferee, you will be complicit because you fund these agencies and sign their paychecks. You're guilty of conspiracy, barratry, and emoluments. Every day you enable this fraud and usurpation, you become participants in child and human trafficking. Representative Fincham, I commend you for acknowledging a compliance problem. That honesty is rare, but the correction must be stated plainly. What you call federal law is itself subordinate to the Constitution, and the Constitution affirms that sovereignty rests in we, the people. You are our servants, as you stated, not our masters. Your role is advisory, to recommend and safeguard, not to punish. Statutes and codes are corporate rules, not the supreme law of the land. When enforced as criminal commands against the people, they become usurpation and treason.
Okay, ma'am. Do you have a personal story with an interaction with the family court? Because that's what this testimony is supposed to be for.
Well, this is about the 5 children, the Burr children, that are about ready to be transferred here, expedited. And so I am notifying this court that if you do accept them, you will be guilty of barratry and of treason.
Okay, so but this is not a personal interaction that you have had with the court,
well,
correct?
this is not, well, I represent those children and that family.
As an attorney, or how do you represent them?
As a constitutional rights advocate. I am not a bar attorney. I have attended law school. I chose not to be a bar attorney.
Okay.
Can I jump in here, Mr. Chair?
Please.
The kids that she's talking about in this family, it's horrendous what's happening. Nevada CPS took control of them. The 3 and 4-year-olds they have evidence that they're being raped repeatedly by foster parents who don't even speak English. And they haven't even seen their 14-year-old daughter. They have no idea where she is right now. So where I'm going with this is, I believe Senator Fincham might be their senator because they're Yavapai, correct? Yavapai County? That's their resident? They're Apache. Okay, so maybe not. But I would love for you to get him the details after, since there's not a lot of time, because he does need to be in the know about this case.
I'm happy to do that.
Quite frankly, we're out of time.
Okay.
All right. Thank you, ma'am. If you would, please get the information to this lady in the maroon jacket, and we'll debrief you, okay? All right, ladies and gentlemen, this is the end of the last Family Court Orders ad hoc hearing. I anticipate that we will have a committee report out within 15 to 21 days. We stand adjourned.